各位贵宾，大家
Distinguished guests, good morning. Once again, thank you for participating the event co-organized by National Human Rights Convention, National Human Rights Commission and the Environmental Rights Foundation and DSET. Our forum will begin officially now, and now that's a round of applause and invite the chair and also president of the Control Yuan and also chair of the National Human Rights Commission, Chen Ju, to give us an opening remark. Thank you. A member of the Aarhus Convention Compliance Committee, Professor Thomas Schomerus, welcome. Also, Division Chief Christopher Sobenbach from the European Economic and Trade Office, and also Chair of Environmental Law Committee at the Taiwan Bar Association, Frank Zhang. Also distinguished guests and our friends who care about environment and human rights, and also our friends online here with us. Good morning. First of all, thank you very much. I would like to first thank Professor Schomerus for coming from afar and helping us, giving us the framework of the Aarhus framework, the Aarhus Convention, and let us look at the climate governance in Taiwan and provide us with suggestions and recommendations. I believe that all the friends here understand that climate change is something that happens every day in our everyday life. It is a crisis. Global climate change means the IPCC, according to the report of IPCC, it says that the Asia-Pacific region, the temperature in this region rises higher than the average globally. Taiwan is an ocean island. In recent years, we've been deeply impacted by extreme climates, especially typhoons, heavy rains, and droughts and floods. These all impact our lives deeply, and it also have an impact on the water resources, on agriculture, and our infrastructure. Gradually increasing Taiwan's cost of living and also risks to human rights. That's why in May of 2022, the Executive Yuan of Taiwan established the National Action Plan on Human Rights. We include climate change and human rights as two of the 8 human rights issues in Taiwan. In 2023, National Human Rights Commission, an independent institution, we include climate change as one of our midterm strategic priorities. We especially focused on how climate change impacts the disadvantaged groups. Also, how we can actually ensure a just transition. How can we face the human rights issues and based on the Aarhus Convention principles. I think that these are our highest priorities. The Aarhus Convention was signed in 1998 in Denmark, focusing on people's participations in decision-making in climate change. We have the right to know, right to have access to information, and also the rights to participate. The public also has the right to litigation to ensure their own right. Even though Taiwan has not become ratified the Aarhus Convention, but it is a good framework for us to review our own framework. That is the access to information, access to justice, and public participation. These are in line with the core principles of Taiwan. Today, we also see that it's a great opportunity that we have this great forum, and I believe that as a Taiwanese society, we have high participation from the general public. And we believe that in terms of the disadvantaged groups, we need to focus more on ensuring their rights. We've already had some mechanisms we have judicial relief for people who are impacted by environmental damages. However, we still need to ensure the accessibility and availability of these mechanisms to disadvantaged groups. We need to continue to see these gaps and try to see how to ensure the access to these resources, legally speaking. So once again, I would like to thank Professor Schomerus for coming here and share with us your insights, and would also like to thank the other co-organizers, including Environmental Rights Foundation, and also I would like to thank the colleagues from the European Economic and Trade Office for also paying attention to this issue. We hope this forum great success. Once again, on behalf of the National Human Rights Commission, I thank you all. Thank you. Thank you, Chair, for the opening remarks. Next, we would like to invite the next speaker to give us an opening remark. The European Economic and Trade Office. I would like to ask Head of Trade Sections of European Economic and Trade Office, Christopher Sorenbach. Thank you. Good morning. Hello, everyone. I'm very honored, very happy to be able to participate this morning's event. I believe that environments and environmental protections is our shared responsibility of the EU and Taiwan. And we also have the same goal, that is net zero by 2050.
With a few more remarks, but thank you for bearing with me, and I hope you understood. So today's topic is an extremely interesting one. We believe that thank you, that, it's fine, it's going to be short anyways. I will be very brief, so it doesn't matter. We believe that the nexus between the environment, environmental protection, and human rights is an extremely important one. It took far too long to recognize this nexus. In 2021, the United Nations Human Rights Council finally recognized officially that having a clean, healthy, and sustainable environment is a human right. Likewise, in 2024, the European Court of Human Rights, which, by the way, is not a European Union institution, which is an institution of the Council of Europe, which goes far beyond the European Union, which is really a pan-European institution, also ruled that one of the member states of this council had violated human rights by not acting strongly enough to stop climate change. We in the EU believe that we are at the forefront of fighting climate change. We want to be a global leader in fighting climate change and protecting the environment. So in addition to our objective to reach net zero by 2050, we are implementing a new strategy which we call Fit for 55. Fit for 55 does not refer to fitness goals of 55-year-olds, but it refers to the objective to reduce climate emissions by 55% already by the year 2030. So we have given ourselves a very important and very ambitious intermediate objective on the way to net zero. We believe that we are on a good path. Already last year, we generated more electricity from sun, wind, and other renewable sources than from gas. Renewable energy constituted around a quarter of the total energy mix in the EU, which is a twofold increase compared to only 15 years before. I would like to conclude by stating that the European Green Deal and our climate ambitions are here to stay. They are a steadfast commitment. They're a commitment which will not change after European elections, which we had earlier this year. We will keep working on implementing the Green Deal, and we are very happy to keep working together with Taiwan in jointly implementing our objectives. Thank you very much, and I wish you all an excellent and very fruitful discussion during today. Thank you.
Thank you. Thank you, Head of Trade Section, Christopher Saurenbart. Next, we would like to invite the next speaker for the open remarks, the Chair of Environmental Law Committee of Taiwan Bar Association, Attorney Zhang Yuying, Frank Zhang. Chair Chen Ju, Christopher Schorenberg, and distinguished guests, good morning. I am Chair of Environmental Law Committee at Taiwan Bar Association. I'm also a practicing lawyer. I'm very honored today to be here on behalf of Taiwan Bar Association. Welcome, Professor Schumerus. Thank you for coming and sharing with us the topic on the development of human rights and environmental rights in the net zero emissions transition. So for today's opening remarks, I want to first welcome Professor Schumerus, 2 sharings and 3 hopes. For the welcome, as I mentioned, I welcome Professor Schumerus from coming afar. 2 sharings. Today on our agenda, we mentioned that we will cover 3 topics, and lastly, we will provide legal recommendations. I want to share with you 2 individual cases that I participated in, and to indicate why the topic is so important today. The first topic is leaving no one behind on the path to net zero. Second topic, human-oriented urban planning adaptation. Topic 3, green energy is good, but community participation is essential. I once participated the first case. The first case is regarding green energy development cases, the PV panel cases. Well, the development area is actually larger than the size of the village. It is actually in Tainan, in Luzhugou. So the application started in 2018, and in 2020, the developers started to get into the fish aquaculture pond and started to do construction, and no information was public. The villagers only knew about this when the equipment got in and started to take out all these water from the pond, and that is only when they knew that the PV panel would be installed, and it was even larger than the size of the fishing village that they live in, which is around 400 hectares, and it would cover the whole village. This case demonstrates that in developing green energy, it didn't follow the spirit of the Aarhus Convention. That is, there is no prior information, there is no public participation, and afterwards, there's no access to justice. And this case is just one of the many cases in green energy development in Taiwan. And this also leads to the problem that in energy transitions, there are complaints and fights from the local communities, or misunderstanding from the local communities. The second case is a metal acid washing plant in the farmland. So how is it related to today's topic? Because today the topic also talk about the urban planning adaptations that is human-oriented. So this is actually an acid washing plant. Starting from 2014, local communities started to protest. The result of the protest is that the first litigation was withdrawn, and the reason is because there is a fake environmental impact assessment, which means that there's no public information, there's no truthful, authentic information public.
这个案子第一次诉讼 During the first round of trial of this case, at that time, the competent authority, the Kaohsiung city government, did a second round of impact assessment that took only 52 days. There is no public participation of local residents in making policies. And that is why in year 2022, the case is withdrawn once again for the second time. And currently, the local residents are still in their fights, and they have only one claim: do not build this factory on my farmland. You can conduct other activities, but no acid washing here. And the development project here has caused the increased risk of floods in the local community, especially with extreme weathers nowadays. The factory is elevated the foundation by 3 meters without any measures in the neighboring area. And that is inconsistent with the spirit of Aarhus Convention. And today I share these 2 cases with you to show you and want to motivate you to participate in all the 3 topics today, and to think about together that the Aarhus Convention's role, pivotal role in the road towards net zero. Thank you.
谢谢。
Thank you to Attorney Zhang. Next, let's have a group photo. It's a group photo session. So for all of our audience members, especially from the sites, if you are okay with participating in the picture, please move towards the center. We'll have a group photo at the audience seats.
空间的关系。
And please move towards the center to join the group photo.
哦，好，那麻烦。
And for our guests in the first row, please shift towards the center. Scoot in a little bit. Scoot towards the center, please. Thank you. Let's have our thumbs up. Next, we will invite the guests from the first 2 rows. Please move on stage. Please move your steps onto the stage. We'll have a group photo among the speakers and guests. And please, Professor Shimurus, please stand next to Chair Chen. Representatives from our organizers and co-organizers, please also feel free to join the group photo.
提醒与会的贵
Here's a reminder for you. So thank you to all of our distinguished guests. Please be seated. Thank you.
那提醒今天与会的观众，
So here's a reminder that there is a QR code for the meeting materials in Chinese, and because we will present in English, so if you want to read through Chinese materials, feel free to scan the QR code. Moving on, we will move into our keynote. Our speaker is Professor Thomas Schomerus, member of the Aarhus Convention Compliance Committee at the United Nations Economic Commission for Europe. Topic is advancing to net zero through human rights, environmental human rights, and climate governance. So first, let us invite the moderator for this session, Commissioner Tian Qiujing of National Human Rights Commission. Good morning, everyone. So today we're talking about a very important issue. Climate change and global warming have early on, since when people noticed it, people thought it was an environmental problem, an environmental issue. Those who pay attention to the environment started worrying, and those who focus on the economy started to realize that it affects the economy as well. And those who pay attention to international issues worry that climate refugee may cause conflicts among countries and even causing wars. However, now we learn that in facing this increasingly dangerous issue, it has been a matter of human rights. Extreme weathers and climate change at first involves generational justice and concerning the future descendants that are not born yet or our children's future generations. And our action has already caused or changed the world that they will be living in. And countries dealing with mitigating and climate change and responding to climate change, we realize that we may have the commitment to change. However, towards this journey, along this journey, we violated the rights of disadvantaged groups. We have made them even more disadvantaged, and we really need to prevent that and address this problem. Looking back at the Industrial Revolution, humans were so proud that we discovered coal, and that can change our lives entirely. We can change the world entirely. And now we need to be responsible for our actions in the past. The Industrial Revolution and the changes that humans caused, we are paying a huge price. So today, as we address the problems nowadays, we really need to make sure that we don't make the same mistakes of the past and causing more problems in our development and advancement. And today, Taiwan is an island. We know that climate change is even riskier or having more drastic impact on us. We already at November and we see typhoons now, and people find it wrong. But we can still need to address that or to face it head on. And because export is really important to Taiwan, to address the problems, we really need to change. It's very difficult to change our industries and the structures. However, on 2021, the International World Day, our chair Chen Ju, the President Tsai of Taiwan, announced that net zero by 2050 is Taiwan's goal as well as the world's goal. And it's almost a mission impossible, but it's something we must do. It's something we must commit to. And President Lai Ching-te, in his office, he already formed a committee on the responses and policies addressing climate change. facilitating international collaboration in addressing climate change. So today we are very honored to invite Professor Thomas Schomerus here.
Schomerus 教授来台。
And we are so honored to have Professor Schomerus to Taiwan. And he's an expert in environmental laws and energy laws. He's also the member of the Aarhus Convention Compliance Committee. We are looking forward to a day that Aarhus Convention becomes a part of Taiwan's domestic law. But at this moment, we need to form consensus because we're a democracy. We really need to form a consensus within our society for the Legislative Yuan to pass this law. And with Professor Schomerus' experience that he shares with us today, we can learn in Taiwan how to formulate the practices that can balance the protection of human rights and addressing climate change. Let's give a round of applause to Professor Schomerus on his talk, Environmental Human Rights and Climate Governance. Thank you.
Yeah, thank you very much indeed for this very friendly introduction. And I'm very happy to be in Taiwan again and to be able to talk to you, and I feel very honored. The weather is not the best at the moment, but I'm used to this kind of weather in Germany. This is very similar. So I would like to talk to you today about the development of human rights and before the background of the Aarhus Convention. And I would like to start with some remarks on human rights and environmental rights, net zero emission transition. I would then come to the role of the Aarhus Convention, look at one or the other case, and give you some thoughts, I try to give you some thoughts on the Taiwanese situation. And so starting with human rights and global climate change, we know that international policy is in danger of failing in the fight against climate change. Currently, we look at COP29 in Baku. And we know that according to the Paris Agreement, we have these nationally determined contributions. That's better? Yeah. Okay. And so nations, however, must, if we look at all these NDCs together, we will end up at 2.5 or almost 3 degrees global warming. So it's not sufficient. So we need a huge fall of CO2 emissions by 2030. And we must cut CO2 emissions by 28% to get on track to achieve the 2-degree goal of the Paris Agreement. And so we need to do much more about that. So my consequence here would be that the nations who came together, who are just coming together at the COP29, they are about to fail. So we need more responsibility of the regions, of the cities. So we need kind of a bottom-up approach here. So, and we also need climate litigation, which is based on human rights. And I think we heard about it today, that in 2019, the United Nations Human Rights Council adopted a resolution on human rights and climate change. And so it's a human rights-based approach to guide global policies and measures designed to address climate change. I won't mention this all here, I won't repeat this all, but I think it is important to know that the United Nations are very committed to climate change, to address, to tackle the risk of climate change, and they also look at a human rights based approach. And we also might have a look at the SDGs, the Sustainable Development Goals, which are not binding under international law, and they do not grant any subjective rights. But they are nevertheless of great importance as a general guideline. So these goals, or there was a report on these goals by the IPCC, which emphasized that deep, rapid, and sustained reductions in greenhouse gas emissions are essential in all sectors to reach the 1.5 degree target or the 2.0 degree target. And with the words of the Secretary General of the United Nations, Mr. Guterres, he said, unless we act now, the 2030 agenda will become an epitaph for a world that might have been. And so we know that addressing climate change is very important. And this is just to give you an example how we could employ the SDGs as an instrument. I said they are not binding. However, it is interesting to compare the performance of states, for instance, looking at all these 17 SDGs. And this gives you an example of a comparison which was established by a German institute, and looking at all the 34 OECD states. Number one, with the best SDG performance, was Sweden. So Scandinavian states are on top. Germany was number 6, but the United States were only number 29 of 34 states. So the US performance were relatively low here. And yeah, and looking now at the role of the Aarhus Convention, and we heard about it. It's about access to environmental information. It's about public participation in decision-making and access to justice in environmental matters. And this marks an important step towards a civil society which is based on individual environmental rights and freedom of information. And Kofi Annan, the former General Secretary of the United Nations, he said that this is the most ambitious venture in the area of environmental democracy. Environmental democracy, a word I like. So a combination of environment and democracy. And civil society, this is important. A civil society with good information, with free access to information, with participation in environmental procedures, administrative procedures, with access to courts. This is what we need, and this is what the Aarhus Convention is about. And looking at the convention, it's based on the Rio Declaration, and it was adopted in 1998. So in a time in the 1990s where we thought that the rule of law, democracy, is going to prevail. Well, we now know that history went on a different path. But it's still very important. We have 47 parties, including the European Union, and Germany ratified it relatively late in 2007. But Germany also is a member, is a party of the convention. Sadly, Belarus left in 2022 because Belarus did not like the principles of the Aarhus Convention anymore. It's a dictatorship. But the convention is open to all United Nations members. Well, I know that the Taiwanese situation is a bit difficult in this matter, but for instance, the first African state entered last year, Guinea-Bissau, a West African state. And we also have a kind of, I would say, a daughter here, which is the Escazú Agreement in South America, which in the Aarhus Convention is a role model for this Escazú Agreement. So the idea of environmental democracy is spreading out even to South America. And yeah, looking now at the Aarhus Convention a bit more in detail, we have 3 pillars. I already mentioned them, but we also have various levels here. And from an EU perspective, we have 3 levels. We have, of course, the international level, the convention itself. We have the European level, because, as I said, the EU is a party of the convention. And the EU, therefore, set up a couple of rules, a couple of laws, regulations, and directives. First of all, regarding the EU institutions themselves, and secondly, regarding the member states. And so, for instance, if we look at the first pillar here, access to environmental information, we can see that there, for instance, there is an Aarhus regulation for the EU institutions, and there's an environmental information directive, which is addressing the member states. And then we have the implementation at national level. For instance, in Germany, we have an Environmental Information Act, we have a Freedom of Information Act, and further acts. So it's a 3-level system here. And this makes the Aarhus Convention, and it makes, for instance, freedom of access to environmental information very strong, because a member state, a European member state, or a party of the Aarhus Convention cannot just change the law if it contradicts the Aarhus Convention. So we are bound by international law. This makes it very strong within the parties. And I just wanted to mention that we have an Aarhus implementation guide, which is also available in Chinese. I think might be easier. Our normal working language, of course, is English, but many documents are also translated in Spanish, in French, in Russian, and, as you see, in Chinese. So our convention has some bodies. So on top is the MOP, the meeting of the parties, which has a bureau. We have working groups. We have, for instance, special working groups or task forces on the 3 pillars. And we have a compliance committee. And you heard that I am a member since 2021 of the Aarhus Convention Compliance Committee. And also since 2021, we have a new institution here, which is closely connected to the Compliance Committee, which is the Special Rapporteur on Environmental Defenders. You see Michel Forst here. And the Special Rapporteur looks at the parties of the Aarhus Convention, looks at how do they deal with environmental NGOs, how do they deal with environmental defenders. Are they punished? Are they criminalized? And he's very critical about many of the parties here. And we have a secretariat, which is very important for us as well. So looking now a bit at the Compliance Committee. The Compliance Committee is a almost unique mechanism in international law. And we have rules here about it, and it says that it should be based, or our findings, our rulings should be based on a consensus-basis. They should be non-confrontational, non-judicial, and consultative. So it's a very diplomatic language we are dealing with here in our compliance committee. And so we try to give advice to the parties. We are not a court. We work like a court, but we are different from a court. I used to work as a judge in Germany at the Higher Administrative Court. And a German court is different from the committee. It's much more formal, I would say. But for me, personally, it is very interesting to work at the committee, to be a member of this committee. You can see that we have members from 9 different countries and various jurisdictions. So we have the common law side with, for instance, our chair, Anya Wild, who is from Ireland, or Eleanor Sharpson, she's a former Advocate General of the European Court of Justice. And we have the French side with, for instance, Marc Clément, who's also a judge from Lyon, France. We have the Eastern European side with Jerzy Androszka, for instance, from Poland, or with Dmitry Skrylnikov from Ukraine. And so we have a combination of various backgrounds, which makes working in the compliance committee, working on the cases, very interesting. And challenging, yes, but it's a very good work. And we very much rely on the Secretariat, and the head of the Secretariat is Fiona Marshall, who's from New Zealand. New Zealand is not a party, but she's a New Zealand lawyer. So what is also, I think, interesting to know is that we have a template which you must use if you want to file a communication to our committee. So you have to use this template, which makes it easy. You need to use it. You need to use it in English. One point is very important here. We always look at domestic remedies. Are there sufficient domestic remedies in the party, within the party? Is the judicial system good enough? If yes, then we say, well, we won't accept this communication because please use your domestic system. And once you have exploited this, then you might come to us. But in many countries, in many states, the judicial system is not that good, I would say. The good thing about this is that everyone can file such a communication, even citizens of Taiwan. Everyone, the public, the general public. And you must not be a citizen of a party of the convention. And the other good thing is it doesn't cost anything. So we don't have any fees. We don't charge anything. Yes, we have a lot of cases. I would not like to invite you to file many communications because our workload is already pretty high. Well, and looking at, for instance, environmental justice here, looking at Article 9 of the Convention, this Article 9 gives NGOs, environmental NGOs, a privileged position because they have access to justice in any case. So the parties of the Aarhus Convention must give environmental NGOs the right to access to courts in the EU, in Germany, in all these parties. And so they don't need to claim that they have an individual, a subjective right which might be violated. It's sufficient if they are an NGO, an environmental NGO. And I think this is quite important here also with regard to climate change. And then, yeah, looking at some selected cases here. I would say that climate litigation, which is based on human rights, plays an ever-increasing role. And you might have heard about this landmark decision in the Netherlands, the Urgenda case. And Urgenda, that's a mixture of urgent and agenda. So Urgenda, that's a Dutch NGO. And they made a decision that the Dutch government must reduce greenhouse gas emissions by 2020 by at least 25% compared to 1990. And this decision was based on human rights. And in particular, it was based on the Charter of the EU Charter of Human Rights. So the right to life and the right to respect for private and family life. And it was also based on the precautionary principle. There are many cases, many cases. I would also like to mention a German case which is still pending, and it has been pending for 9 years already. It's a case of a Peruvian farmer who lives high up in the Andes mountains, and he lives beyond or under a dam, a lake. And due to climate change, the ice, the glaciers are melting. And so the water level in the lake is rising, which means that they have to heighten the dam, which costs money. And he filed a lawsuit in Germany at a German civil law court, against the German energy company RWE. And RWE is an operator of coal-fired power plants, and it's responsible for about 0.6% of global greenhouse gas emissions. So he says, I want 0.5% of the costs to heighten the dam from RWE, which is like 10,000 euros. Wow. I think that's a very interesting case. We don't know the outcome. As I said, it has been pending for a long time. There are many other cases. And if you want to look at a good documentation, look at the Seven Center for Climate Change Law at the Columbia Law School in New York. Well, I also would like to mention a very interesting landmark decision of the German German Federal Constitutional Court. And we have a Climate Protection Act in Germany, which came into force in 2019. And this act says we have a 55% reduction target by 2030, and we wanted to achieve greenhouse gas neutrality by 2050. This was the old act from 2019. And then we had also had sectoral responsibilities. So the ministries in Germany were responsible for certain reductions, annual reductions. So they were made responsible to achieve these reductions. And so you can see that, for instance, the energy sector has now to reduce from 280 million equivalent to emission tons, CO2 tons, in 2020 to 108 by 2030. This is very challenging, but they are going to make it because we are going to phase out coal. In May this year, this law was changed. There were a lot of discussions about this amendment of the law because the sectoral targets and the compliance mechanism were kind of abolished, because now the whole government and not the individual ministries and the ministers are not responsible anymore. So it was weakened a bit. But what the Federal Constitutional Court said is that climate action is meant as an intertemporal protection of freedom rights. So it's about freedom. And so they said we have to mitigate high emission reduction burdens which are required by fundamental rights to safeguard freedom over time and over the generations. And they said that this 2019 Climate Change Act was not compatible with the basic law, with our Constitution, with the freedom right in the Constitution. So it had to be changed. Our Constitution says that every person shall have the right to life and physical integrity. And this human right is in danger due to climate change. And what the court further said was that this right to life includes the protection against impairment of fundamental rights by environmental pollution, regardless of by whom and through what circumstances they are threatened. And the state has a duty to protect life and health from the dangers of climate change. And it can also establish an obligation to protect future generations. And we have Article 20A of our Constitution, which says that the state, also in its responsibility for future generations, must protect the natural foundations of life. So the state has the duty to protect us against the dangers of climate change. And so this is a combination of these two articles of our Constitution: the individual human right to freedom and life, and the state obligation to protect the environment and to protect us against the dangers of climate change. And and then we also had other cases. For instance, we had quite an interesting case of the European Court of Justice, which interpreted Article 9.3 of the Aarhus Convention in a number of judgments. And this judgment here was about a case of the environmental NGO Deutsche Umwelthilfe, which is a kind of legal-based NGO. And the government respects it, I would say. Highly respects it, because they work very well. And you know about the scandal about vehicles with prohibited defeat devices, the VW. But it wasn't only VW, it was, I think, many cars had this problem. And the court said that there's a right of NGOs of access to courts in this matter. So they have a right of standing. And and the court also said that there's actually no cooperation relationship between the European Court of Justice and my Aarhus Convention Compliance Committee. So we are never quoted, we are never cited by the European Court of Justice. But we are cited by the Advocate Generals. So it's a kind of a tricky relationship here. And then we had this very interesting case as well about this Swiss Klimaseniorinnen, so elderly ladies in Switzerland and their association, I think we heard about this today already. They filed a lawsuit at the European Court of Human Rights, which is, as we heard, not the EU Court of Justice, but it's a different court in Strasbourg, in France. And this court ruled in favor of the plaintiffs here. And they said they have standing, and they based it on partly on the Aarhus Convention, on Article 9.3 of the Aarhus Convention. And the interesting thing here was that the four ladies who went to court were not given standing, because the court said, well, or what the court thought was, well, you are elderly, you cannot tell us that you are severely infected now by climate change. This is, okay. But the court said, okay, yes, the association has standing. The association can go to court. So they won in the end. In the German case I mentioned before, it was the other way around. In the German case, because it was based on Article 2 of the freedom right, the association was not given standing, but the individual claimants were given standing. So it was just the other way around. But that's lawyers. I mean, yeah. So that's how lawyers argue. And there was another interesting case also in Germany, which was at the Higher Administrative Court of Berlin and Brandenburg, so Berlin as our capital, and which was also about, also the claimant was this NGO Deutsche Umwelthilfe, and they said that they have standing with regard to the Climate Change Act emergency program. So the old Climate Change Act in Germany said that if the sectoral targets were not reached by the ministries, then there was an automatic mechanism that they must take measures, must take sufficient measures to get there. And this court, so my colleagues, I told you I'm a former judge. My colleagues, they said, well, according to German law, this association this NGO has no standing. But they employed the Aarhus Convention and they employed the European Charter of Human Rights against German law, saying, well, we provide you with standing. And I think that was I like this decision. I like this judgment. So. And sometimes judges can be progressive, sometimes. Yeah, now I would like to give you some thoughts on the situation in Taiwan. I'm very careful here because I'm not so familiar with Taiwan or with the legal system. I've been here a couple of times. I love Taiwan. I love the people. I love the food. Sometimes the weather. But it's, of course, and I also know that the Taiwanese legal system is, to a certain extent, based on German law. And so many of my colleagues, the legal scholars, they studied and got their PhD in Germany, which I really appreciate. So I feel a bit like home here. So, but as I said, I'm a bit cautious here. But looking at, for instance, at this pursuit of net zero along the path of human rights, which is the topic of our conference here, so about environmental, human rights, and climate governance, I would like to remind you that the Aarhus Convention is about procedural law, access to information, participation, access to justice. It only indirectly affects substantive law. So there are no material standards in the Aarhus Convention. So there are no climate change targets, or climate targets in the Aarhus Convention. And we also know that there's no subjective, substantive right to a healthy environment in Taiwan, as neither in Germany. And okay, thank you. And so the point is that it's only procedural rights, but nevertheless, the Aarhus Convention is very important here. And the Aarhus Convention also says that every person has the right to live in an environment adequate to his or her health and well-being. But this does not give us the right of a healthy environment. It's just, that's a preliminary sentence here. It's not part of the binding Aarhus Convention. And so I would just try to look through the three pillars of the Aarhus Convention here. And I was just told I have only 5 minutes left. But if I won't finish here, I think in the last part of our conference, I would come back to this here. So then I think, yeah, that's okay. Thank you. Yeah. So what I heard about the situation in Taiwan, and I was informed a bit. It said that it is questionable whether people can know the content of the draft before a public hearing. So it's about access to environmental information. And well, yes, everyone has the right of access without an interest having to be stated, and in the form requested, in principle. There are, however, some procedural rules. For instance, there are tight deadlines for the public authorities. There are rules for exceptions. So if it's only a draft, it might fall under an exception, according to the Aarhus Convention. It might not. An advice I would like to give you is, on the basis of our German situation, is we have a website. It's a private website run by an environmental NGO, or run by an individual, Mr. Semsrott, and this is called fragdenstaat.de, Ask the State. And this private website offers free services for applicants who want information from public authorities. And it's very effective. It doesn't cost you anything. And I think this might be an idea for Taiwan as well. So maybe you have it already, but I don't know. But such a website is very helpful for people who are not so familiar with the regulations. And so I think, why not? Let's, if you don't have something like that, NGOs might start it. As I said, there are a couple of exceptions according to Article 4 of the Convention, but all these exceptions must be interpreted in a narrow manner. And so it also means that if the public interest prevails, of getting the information prevails against the private or the public authorities' interest to keep it secret, it must be disclosed. The information must be disclosed. So the exceptions are, yes, they are necessary, but they should not be an obstacle to freedom of information in general, I would say. Okay, thank you. So I would just stop this part here and just go to the end, and I will and then in the last part today, I would come back here. You see there are a couple of further slides. So just to give you some preliminary conclusions here, I would say that human rights and environmental rights are very important for net zero emission transition because, as I said, international policy is failing to reach the Paris Agreement targets. And so the Aarhus Convention, which assumes the right to life to live in an environment adequate to his or her health and well-being, is of great importance here for an informed, for an enlightened civil society. And this does not only refer to states without a democratic and constitutional tradition, but also might also refer to like Taiwan, which is very democratic and rule of law state. And so the Compliance Committee offers an effective review mechanism. Effective, yes, it takes a while. Because we as Compliance Committee members, for us, it's a hobby. We love it, but it's not a full-time job. But nevertheless, I think it's quite effective. Climate litigation is important here. All over the world, we can find such cases. And in Germany, I told you about this Constitutional Court judgment, which I think was one of the most important worldwide. And although Taiwan is not a party to the convention, I think it seems to have adopted many of its requirements, although there's nevertheless always room for improvement. So thank you very much for your attention, and I look forward to the further discussion. I look forward to our conference here. Thank you very much.
那我们就
Once again, a round of applause for Professor Schomerus for the wonderful insights. Because we have limited time for this session, so we don't have time for Q&A. If you need to ask questions, welcome to stay with us till the last session. We'll have time for plenty of questions. Next, we will take a 5-minute break. Outside the venue, we prepare black tea, green tea, and coffee. Please enjoy. And in order to avoid one-time disposable utensils, please prepare your own containers. Also, food and drinks is allowed in this venue. We'll take a 5-minute break.
let us welcome the moderator of this session, Associate Professor Lin Chunyuan of College of Law, National Taiwan University. Professor Lin will be our moderator for this session. Chairperson Chen, Commissioners of the NHRC, Professor Schummerus, hello everyone. I am the moderator for this session. I'm delighted to serve as a moderator for this session. Our topic is leaving no one behind on the path to net zero. And today we have the NHRC and Environment Rights Foundation to host this interesting forum on this such a pivotal issue. It's such a great opportunity. We've known that we passed the Climate Change Response Act, and ministries and departments of our government have spared no effort in promoting such policies. However, as we look into the discussions by the CSOs and the government, the topics and discussion revolve around economy and technologies and international trends. And oftentimes we find that rarely people talk about human rights in discussing environmental issues. As we all know that climate change, its implications affect every one of us. And environmental policies, net zero policies, also impact every one of us. So today we're delighted to have Attorney Huang Xingwen from the Environmental Rights Foundation to present on this topic. And I'll also introduce our discussants. We have 3 discussants for this session. Originally, we invited Legislator Hong Shenghan and the Deputy of the Director General of the Climate Change Administration were not able to attend due to their schedules. So the discussants today are Director Zhang Fuling of Department of Social Development, National Development Council, and Deputy Director General Huang Weiming of Climate Change Administration and Ministry of Environment, and Commissioner Tian Qiujing of National Human Rights Commission. And without further ado, let's give a round of applause for our presenter, Attorney Huang. Thank you all for coming to this forum. I'll go straight into our topic. I will talk about the perspective of Aarhus Convention, about having the 3 pillars: open information and judicial relief and public participation, to look at the procedures in Taiwan. Climate change may be disputed in certain countries or jurisdictions, but in Taiwan there is no dispute here that it's facts. And it's because of human activities, burning the fossil fuels and clearing forests, have caused global warming. And IPCC AR6 presented that there is a near linear relationship between cumulative anthropogenic CO2 emissions and global warming. So for many years, we've been trying to address global warming and greenhouse emissions, and unfortunately, the emission is still at the heights in recent years. Unlike other OECD countries, there is a decoupling between GDP and greenhouse emissions. However, in Taiwan, our emission per capita and the entire country has been on the high levels. And global warming is not just about the weather becoming hotter, but the environmental impact. For example, sea level rising and glacier melting, and it also affects the ocean. When temperature changes, all these natural systems would change as well. That is why, that is the cause of extreme weathers that we see nowadays. And CO2 dissolving in ocean water also cause ocean acidification. And these changes also cause extreme weather such as heat waves, heavy rains, droughts and floods, and affect food safety and damage to infrastructure and water safety. And all these would violate or cause harm to right to life, health, subsistence, housing, work, property, and cultural rights. Professor Schomerus mentioned that they also affect or may harm environmental rights. However, in Taiwan or Germany, environmental rights is not recognized as a fundamental human right. However, it is within the international human rights scope. To address climate change, government, individuals, companies need to take actions. And climate actions fall under two categories: mitigation and adaptation. And because we want to talk about national targets, reduction targets, so we will fall under reduction, that is mitigation. And going to Paris Agreement, we have this restriction within 1.5 Celsius and 2 degrees. And IPCC AR6 also proposed the carbon budget to control the rise of temperature within 1.5 Celsius degrees to 2 degrees. And under the global carbon budget, there should be a carbon budget for each country or jurisdiction. To calculate that, we need to have this reduction target at the national level. For climate governance, we have multiple levels, including international levels and country levels. And for the country levels, the most basic framework would be national reduction targets. And under reduction targets, there would be sectoral reduction targets. And for Taiwan, there will be 6, including energy, manufacturing, business, and residence and transportation, agriculture, and environment. So with these targets, we also would have practical measures. So that's the entire framework here. So for the national reduction targets, it serves as the top at the regulatory framework of climate action to implement measures to limit target temperature rise between 1.5 to 2 degrees, and also leads sectoral reduction targets and action programs. And climate change, as well as climate action and climate policies, would all affect human activities, because all human activities involve greenhouse gas emission. According to the latest reports by IPCC, if emissions associated with pre- and post-production activities in global food system are included, the emissions are estimated to be 21 to 37% of total net greenhouse emissions. For transportation, it accounts around 23% of all global energy CO2 emission. And for all household appliances, including the AC, all the manufacturing and the usage of all these objects involve carbon emission. I'm not saying that this should stop us from taking climate action, because we really need to take actions to prevent entering this critical point. So we need to take actions. However, we need to recognize that climate action actually have impact on human activities. When we amend regulations on the renewable energy regulations, it's stipulating that all buildings need to install PV panels on the rooftop of the buildings, and the people already proposed that there would be a damage to rights to property. And in the past, for air pollution regulations are amended, many bus drivers or such industry also say that they would affect their right to work. And in the previous, because there is in the German Federal Constitution Court, the Basic Law imposes this obligation, saying that if we fail to meet our targets, the obligation will be passed on to the future generations. So we are violating or harming the rights of the future generations. If we don't take reduction actions now, we would affect the future generation, and that harms their rights. So this should not be allowed. So whether it's it's climate action or climate change, they affect our fundamental rights. And there should be proper procedures to protect respective fundamental rights. including both physical rights as well as procedural rights, so that people need to be able to participate in the entire process to express themselves because they affect their physical rights. And we've just looked at the state duties, and we can look at the Climate Change Response Act and the actual measures. And I want to distinguish between the national periodic regulatory goals and national reduction targets. For Taiwan, a national periodic regulatory goals is a goal for net greenhouse emission for a certain period of time. In Taiwan, it's 5 years. And for national reduction targets is a percentage of net greenhouse emission in the target year compared to the baseline year. So let's look at an example. So for the national reduction target for 2025, that is a 10% reduction compared to the 2005 level. And in the same time, the national periodic regulatory goal of the period from 2021 to 2025 is set at 1,400 metric tons. So that is a percentage and an amount.
Now let's go to the concrete regulations. The long-term objectives is on the national reduction goal, whereas the short and mid-term is on national periodic regulatory goals. For the long-term ones is the reduction goal, that is net zero by 2050, which we are all familiar with. For short-term and mid-term targets, it's the legislators commissioned the Ministry of Environment to regulate these mid-term and mid and short-term. So it's simply short, it's about having a public hearing, and the date and time of the public hearing needs to be announced 30 days in advance. So it seems that we have a public hearing, so it seems like people know about this. It seems that it's the public participation is guaranteed. But let's look at the 3 pillars of the Aarhus Principles, and let's see what are some of the things lacking in our own framework. First is, as the professor mentioned, can the public access the draft contents prior to the public hearing? This is important because if I want to actually provide recommendations and comments on the public hearings, I know nothing about it, I don't know anything about the draft content, then me participating would be meaningless. So that's why in the guidelines of the Aarhus Principle, it mentions that in order to ensure effective participations, you need to also have access to information. That is, in order to ensure public access, you need to make public the draft contents, because you don't need to know what you need to comment on so that your participation can be meaningful. In our in our Climate Act, only the date, location, and the format of the public hearing need to be made public. The content is not included. Even though the executive yuan did make public this information, but the content would only make public after the public hearing. So before the public hearing, currently, the law didn't guarantee that the public would know these information in advance. So it seems that this is something lacking here. But my recommendation is that since we have officers from the Ministry of Environment here, in order to ensure effective public participation, please still make public the information, make public the draft contents, that is 30 days before the public hearing. One thing that also needs to make public before the public hearing is that the references that you refer to, that is, if we want to understand why is it the competent authority look into and the considerations of the competent authority, so that the public will understand why is it we're thinking differently, or maybe there is imbalances of this information, so you can have an effective informed information. And that is why Article 5-7 of the Aarhus Convention mentions that each party shall publish the facts and analysis of facts which it consider relevant and important in framing major environmental policy proposals. So we need to know what are the considerations in making public these Climate Act. it also mentions that this information needs to, relevant competent authorities need to provide information to the Ministry of Environment for reference, which includes the forecast of the needs of the electricity, the growth of the needs of the electricity demands, the reduction scenarios, etc. And then the competent authorities will look into those. However, the Climate Act did not say that this information also needs to be available for the general public. Therefore, when the general public do not know this information, it's hard for them to meaningfully and effectively participate. So we recommend that while we're making public the draft contents, also make public this information. But of course, as the professor mentioned earlier, if there is something of confidentiality, or if some political considerations or trade secrets or national secrets, you can also cover those information before you provide this information to the public. The third thing is not of a legal issue, but an implementation issue. According to Article 10-4 of this Climate Act, the competent authority shall establish a regulatory goal for the stage 2 years ahead of the beginning of the next stage. The reason it needs to be proposed ahead is because this would greatly impact our individual lives, even the whole sector in the industry and the society. We need to know how it will impact us before we prepare for it. For instance, if a company knows that high emitted materials may be prohibited, or the cost will significantly increase, then the company would be able to find alternatives in advance to reduce these, the impact of the climate action. And that's why this is important to make public in advance. So that's why the regulations say that it needs to be proposed 2 years ahead. Now, the starting date of the Climate Act is January 1st of 2026. So 2 years ahead would be January 1st of 2024. But when we talk to the Ministry of Economic, they have a very innovative legal interpretation. Even though it says that, yes, it starts with January 1st of 2026, but we don't look at the dates, we look at only the year. So 2 years prior means 2024. This means that we only need to make public by the end of 2024, that is December 31st of 2024. Let's neglect these very innovative things for before that, but is it possible that the Ministry of the Environment would be able to make public by the end of this year? Because the Climate Act did say that it needs to be made public relevant information 30 days prior to the public hearing. And we also need 30 days before that, so it should be 60 days before. But it's already 60 days. We are already at November. We haven't received any information. It seems that it would not be able to be done by the end of this year. The problem is that, can the Ministry of Environment take public participation feedback into account? This thing is important because I spend a lot of time getting a lot of people coming in, having all this cost and energy, but then it's like a firework. When it's done, it's done. Then it means that this public information would be meaningless, and that's why the Aarhus Principle mentions that the results of the public participation should be taken into account as far as possible. The reason we question the ministry is because actually the National Development Council already made public the information in 2022. It is 24% plus minus 1%. It doesn't have a legal binding effect because it is not a competent authority. But we already talked about the definition differences between national reduction targets and periodic regulatory goals. But they are meaning the same thing. That is, we need to reduce that. What is the timeline? So the setting of the national reduction targets actually determine the formulation of the periodic regulation goals. And be it phase 1 or phase 2, when the Ministry of the Environment make public information, they will also make public these periodic regulatory goals. So when the National Development Council make public, the Ministry of Environment also confirm and say that yes, indeed, we will follow the statistics made public of the National Development Council. And of course, if the Director General says otherwise, please correct us. Then if it's based on this, whatever recommendations we provide and whatever feedback we have, we already know that they will not affect the end results. The targets is already set. Then why do we even have public hearings anyways? This is actually something the cons of public participation, you get a lot of people coming in who already had the conclusion ready. And that's why when we are implementing public participation, this is something that needs to be improved. Otherwise, these public hearings will only be a formality. And we think that the results of the public participation should still needs to be included to be in line with the Aarhus Principle. Next thing is about access to justice. Even though the Climate Act doesn't include provisions of public interest litigations, even though we in the CSOs has advocated for this for a long time. So currently, these climate is called like classified as a regulation, administrative regulations. Now the general public has no claims over administrative regulations or the regulations and orders. So that's why there's no protection on the public's rights to seek judicial relief, even though we at the CEO still try to file for a constitutional litigation. We say that our rights is infringed, but we don't have the rights to judicial relief. That sort of violated our right, access to rights. We're saying that the right actually violates our rights. So we're jumping outside this framework. But what we're saying is that currently the law doesn't protect public's rights to seek judicial relief. Just to summarize in a few statements, we've mentioned that there's 3 pillars of the Aarhus Convention, that is public information, public participations, and also access to justice. This is to ensure environmental democracy, addressing the shortcomings of representative democracy and expert governance. People can directly participate in the democracy and to further deepening democracy. The objective of the national reduction plans involves not only the industry, but also societal and individual lives. So it requires more people to participate and make the decision together. Take Germany and Korea, for example. It needs to go as far as the parliament in order to ensure the requirements of national reduction targets. But if the law already requires, even though we're also challenging the law, but if under our existing legal framework, we ask the administrative branch to actually burden the responsibility of setting up the national reduction targets, then democracy still needs to be guaranteed in order to meet the requirements. But based on what I've talked about, be it the implementation phase or the legal phase, there's still a lot of room for improvement. So these are some of my recommendations and suggestions. Thank you. Right now, I would like to invite all the presenters and panelists to be on the stage. We will start the panel discussion session on this session. We will ask once again Associate Professor Lin Chunyuan as the moderator. Good morning, everyone. Thank you, Attorney Xing Wen, for the very wonderful presentations, pointing out many issues, and I think we would be able to ask our fellow panelists to respond to these issues. Just to correct some of the orders, the panelists would first start with people from my right-hand side, Commissioner Tian. No, sorry, we'll ask you to start first. We'll first ask Commissioner Tian Qiujing to start first, and then afterwards, we will ask Deputy Director General Huang Weiming, and then the Director of the Department of Social Development. So without further ado, Commissioner Tian, thank you very much. Thank you. I would like to thank the presenters for the very wonderful presentations. I think hearing her speech reminded me of me as a legislator proposing the Greenhouse Gas Emission Reduction Act. Now, when it was passed in 2005, it was the first in the world that regulates the targets and the timeline of reductions. Now, I was at the opposing parties, and I was strongly objected. The industry also objected. But all I'm saying is one thing, that people said that no one did this before. And I said that exactly because of this, we need to do the same thing, because we're not an UN member. We have a very good economic results. when climate change affected us greatly, then they would definitely sanction Taiwan. It is so easy to sanction Taiwan, which would yield to great results. And that's why we need to do it first within our framework. This is a way to show our determination and our political will. Back then, the industry was very angry at me, but luckily, back then, legislator Cho Wen-yuan, who is the ruling party back then at KMT, and she supported us, and we said that we are not a member at the but we were not able to actually go to the negotiation, and we only have a very few vessels at the Atlantic, and then even people need to monitor us on these vessels, so it is very hard. So if we don't do it now, once we were sanctioned, we would definitely be in a chaotic, we would not be able to respond. So we were very thankful for ultimately support from the industry.
后来听懂了。
And the industry chair understood, then they convinced and persuaded the public groups to help pass this law. And I convinced the head of EPA at the time. At the time, COP21, President Ma wanted to go to Paris and to show everyone that there is a new law in Taiwan, to advocate that, to advertise for Taiwan. And I said to the head of EPA then, saying that they need to have all these different ministries, including the Ministry of Economic Affairs and Agriculture, etc., needs to be put in, because the competent authority cannot be solely the Environmental Protection Agency. If without the implementation of other ministries, if the upper tiers of these ministries are not involved, then the law cannot be implemented. So it took a lot of time for us to come up with this Greenhouse Gas Emission Reduction Act that incorporates multiple agencies and ministries, requiring the competent authorities to set reduction targets and implementation measures. And we talk about the periodic regulatory goals. And that is the carbon budget in UK law. However, we cannot put carbon budget into our domestic law, because that would be in contradiction with our fiscal budget regulations, and that is why we named this periodic regulatory goals. However, in the implementation of this law, we mentioned that that actually refers to carbon budget. So this is an experience of that time. In that we went so far to put all these different ministries into the law. And however, in 2021, President Tsai announced that we need to meet international standards and to approach net zero by 2050. That's an even more ambitious goal. However, as of 2023, the Climate Change Response Act passed even without any fight. So this shows that all of us have already recognized that if we don't clarify the ultimate goals, and it's impossible to do so. And all these targets and all these goals are the responsibility and obligations that we can never shine away from anymore. And to domesticate Aarhus Convention may be an opportunity for us. Our presenter mentioned all these challenges in the existing regulations and procedures. If we can make Aarhus Convention a part of domestic law, in other ways, we cannot ratify it in the UN system, but we can pass it in the Legislative Yuan. And Professor Schomerus talked about that Aarhus Convention is a soft law. It's similar to the ideals, the aspirations, or is a guiding principles for us in practice. And with Aarhus Convention as guidance, our public officials may refer to that with more specific goals, and the government agencies can work better with the private sector and the CSOs, just as how we have more precise goals because we have already domesticated CRC. As long as we can cite the articles within CRC, when we negotiate with different agencies, we can just go right straight into very specific actions. And Professor Schomerus mentioned that Aarhus Convention is a procedural convention. Procedure matters. It's so important. In my experience in the legislative yuan, without procedure, there's no justice. So with procedure, we can guarantee that the end results is consistent with, can fulfill public interest. And we're all very familiar with an example that's against the procedural laws, the Sunflower Movement, because at that time there was such an incident violating procedural laws, and how that's why the students went into legislature to protest. And the Sunflower Movement forced the government to take procedures seriously to ensure procedural justice in passing the laws. So going back to the Aarhus Convention in the 3 pillars, I know that many officials from the executive branch are quite fearful for public participation because they find it burdensome. But with public participation, all these transparent processes can ensure implementation can go well going further. When I was younger, the elections are not transparent, and there are political incidents involving elections. And afterwards, the voting procedures are more and more transparent and more open, and now elections in Taiwan now are actually known in the international community as a very transparent process. So transparency can ensure the frontline public servants not being objected and to fulfill their work smoothly and to have a better relationship with the general public. So it would be easier to convince the general public if we have transparency. And that can help us to fulfill, that can help us to implement the practices and policies that are meant for the public interest. Because without such transparency, the public servants need to face the challenges and hiccups in practice. And even though they meant well, but they cannot have a sense of achievement, and it also affects morale. So that is unfortunate, and we really need to prevent that. And even though we cannot put Aarhus Convention into our domestic law immediately, we need to refer to it to ensure a discussion we need to incorporate the spirits in practice in Taiwan, even without it being a part of domestic law. And for the Climate Change Response Act, that is more progressive compared to the 2015 Greenhouse Gas Emission Act, with specification on just transition. And just transition is very important. It's very important guarantee or protection of a human rights-based approach. So that reflects to our goal today, our topic today, following human rights towards net zero. Without public participation, nothing can be done. None of this can be achieved. Without public participation, without open information, transparency, it's very difficult for us to ensure just transition. And when the general public faces a lot of frustrations, there would be a distrust between the people and the public servants. And the public servants also also cannot have a sense of achievement in pursuing these goals. And this is something we really need to address immediately. And we really need to recognize the problems before we find solutions for them. And my time is up, so I will wrap up my response here. Thank you.
非常谢谢田委员。
Thank you to Commissioner Tian for the discussion, and thank you to Commissioner Tian's efforts in the Legislative Yuan. Before, the majority of people pay attention to environmental rights, and now Commissioner Tian is no longer a legislator, but serves as a commissioner at the NHRC, constantly monitoring the environmental rights. To extend from the keynote of Professor Shomura's talking about the procedural rights, in a sense, we often say that Taiwan has all these rights in place already. But from our presenter, we know that from the perspective of human rights, in practice, we find that, oh, indeed, we have all these instruments, all these vessels, but none of them are working. None of them are working well. And Commissioner Tian tells us that we can think about our procedures in the spirit of Aarhus Convention and to deepen the spirit in practice. And our next two panelists have received the most pressure and stress at the front line of net zero transition, the public servants at the front line. So first, let's invite Deputy Director General Huang of Climate Change Administration from Ministry of Environment. Thank you all. In response to the presentation of Attorney Huang, especially the explanation on Climate Change Response Act, I have a few responses. Indeed, response to climate change is a challenge of the executive branch. I personally served at the Ministry of Environment and the EPA. I have worked for 30 years in this area, and this issue is basically my work. I started out working on air pollution prevention and climate change response. From the legislation journey, we learned that after the passage of Climate Change Response Act, the purpose is, the law has this ultimate purpose of achieving net zero by 2050. And as Commissioner Pien mentioned, that when we put out the 5-year target in the Greenhouse Gas Reduction Act, so that such reduction target passed down to Climate Change Response Act as well. And the targets, the ways that we set targets may raise concern, but for the previous journey, in holding public hearing, in publicizing information, we do want to publicize such information to our general public before the public hearing. We want to have people to have access to such information. So in the public hearing, there is this 1 month regulation stipulating a 1 month prior to the public hearing. And for the dates and the content and the targets of the public hearing, we do also provide the general targets for the between 2026 or 2030, including the different sectors of energy, manufacturing, and residence, agricultural, environment, etc. We actually ensure that the general public or participants of public hearing would have the draft before they attend the hearings, and at least that is within our plans. We want to ensure that. And then the periodic regulatory goals. Back in 2022, the NDC was in charge of setting the 12 strategies towards net zero. And at that time, the UN was also reviewing NDC 2.0. So because we are a member of international community, we are also reviewing the goals as well. That is why we propose this new target of 24 plus and minus 1%. And we do have a certain methodology, having all the respective ministries reviewing the applicable resources and capacity by 2030. However, after we put out such targets, many people find the targets not ambitious enough. But the executive branch also needs to emphasize the challenge in achieving such goals. And for the 24 plus and minus 1%, this target is something that we are reviewing at the moment. Earlier this year, we've already formed a technical task force to review the content of the targets. As cabinet reorganization with the new administration, we want to take a step further in our targets. And the cabinets have been discussing with ministries of the room for improvements. Starting with the bottom-up approach of the past, we also want to set more ambitious targets from top down. And the work is ongoing at the moment. We want to decide on the specific plans, and as soon as we have that, we will hold public hearings to communicate that with the general public. And for the targets and the climate action,
globally, indeed, many states does do this, but also some states fail to do so. The emission gap report published by the UN last year mentioned that out of the G20 countries, 19 countries did set up their national reduction targets. One country failed to do so. Only 9 countries include them in their domestic laws, and only 10 of them provided concrete action plans. So I'm saying that executive branch has already worked very hard, even though for our reduction target, people still needs to be more aggressive. But this means that this is something that we want to continue to increase. And of course, people will also question the target and asking whether or not it is ambitious or whether we can be more ambitious. Indeed, the target that we set, we've actually tried to compare with nearby countries in Asia. That is, by 2030, what are the reduction targets in neighboring countries? After our comparisons, it seems that the target proposed by Taiwan, even though we feel that 24 plus minus 1 is not ambitious enough, but it is only second to Japan in Asian countries, not to mention Korea or Singapore. The target in Singapore, if you calculate this, compared to 2005, it would want the reduction is to increase 65%. China, not to mention, that is an increase of 57% compared to 2005, whereas we are to reduce 23 to 25%, whereas Thailand is to increase 27%. What does that mean? This means what the climate convention mentioned. Each country has its own difficulties and struggles, so each country would have its shared responsibility but differential responsibility. And of course, if your target, if all combination, as the attorney mentioned, it's not enough, and it is in by the end of this century, we would not be able to achieve the target of 2 degrees or 1.5 degrees. If that's the case, we would increase as high as 3%. So of course, 3 degrees. And of course, the convention is also reviewing this once again to see if we can have an updated target. And at the presidential office level, well, the climate change response team continue to propose this, and this is also something that we work on. So at this stage, we will first focus on the target by 2030, and then afterwards, for the next phase, we will achieve it try to set the target for 2050. But the key thing is about implementation and not just about setting the target. Of course, we're also under stress, but we hope we can at least achieve concrete goals from the administrative branch. Okay, thank you. Thank you, Vice DG. It seems that there's still a lot of information and difficulties that maybe we can continue that conversation later. Next, Director Zhang from the National Development Council. Follow up on the explanations of Deputy DG. Actually, if we look at net zero by 2050 and the roadmap, indeed we did collect and received. We look at the trends of the climate conventions. That's why we have the urgencies to propose our own version. And in 2021, the former President Tsai Ing-wen announced net zero by 2050. According to the Greenhouse Gas Reduction Act, it should be set by the Environmental Protection Administration. But the reason the National Development Council set the target is because the presidents also hope that if it's possible to look at it in a national overall plans and to see if you can set a plan. That's why it is set by the NDC, as the Deputy Director General Huang mentioned. We talk also to relevant expert scholars, and we also have public hearings. And in April, collaborating with the International Earth Day, we had a policy announcement. During this process, even though we set up the pathway, how to set up these targets and goals and how to realize these pathways, it depends on different government agencies. For instance, there's the collection of this information and setting of different targets. We still have like a general discussion process in between. So at the Ministry of Environment, at the climate public platform, you also see the competent authorities from different departments who also have their own public hearings. But coming back to what we all care about, what is the procedure like? During this process, more strictly, before the domestications of the Aarhus Principle, what Commissioner Tian mentioned is very good. If we can domesticate the Aarhus Principle just as other international human rights conventions, then it would be a good legal basis for us. But before that, we have actually a procedural act, Administrative Procedure Act, which has requirements to public hearings. And I think we can talk about what's the requirement for public hearings. But because of that, on December 28th of 2022, when we make public these policies, we start to see some discussions. And competent authorities for these key strategies at the same time have also been collecting different feedback. One special thing is that, as the professor mentioned, just transition. Out of the 11 strategic plans, we start to add a new strategy, that is just transition, which fall into the jurisdictions of NDC. On December 28th, back then the Climate Change Act was still the Greenhouse Gas Emission Reduction Act. Back then, the Climate Change Act didn't have a clear definition, but because of people's discussion, especially under the Environmental Protection Associations and the legislators' request, we transitioned this Greenhouse Gas Reduction Act to Climate Change Act. As for the Climate Change Act, it was made public on in February 2023. So we cannot achieve the targets over one night. So back then we set the target as 24 plus minus 1. We wanted to, combine both the reality and also our aspirations. So it's not that it's a fixed target that cannot be changed. After the new government, we try to accelerate the process and we review this process as well. And that's what the Deputy DG Huang just said. So be it the policy review meeting organized by the Vice Premier, we also want to not only have a top-down approach, but also we not only want to have a bottom-up approach, but also a top-down approach. So at the, as we mentioned, at the presidential office, we also set up a climate change response team, asking each ministries to review their own policies and as Commissioner Ye mentioned and reminded me before the meeting, it seems that this falls into the jurisdiction of NDC. We will need to review this policy, but it's not just the responsibility of NDC. It will also have the other implementation authorities of these strategies. So we would also review this through public hearings. That's what the procedure is like. As for just transition, coming back to this topic, we're also working hard on it. More concretely, once number 12, that is just transition, was established, we quickly established the just transition committee. The model is very similar to OGP model. So we have public officials being half of the committee members and half of them from public sectors. So at least through these platforms, they will be treated equally. Currently, within the committee, we've already had 4 meetings, but it seems like it's only 4 meetings, but we still have working group meetings. So we would like to thank the civil societies, maybe from the environmental protection organizations and legal experts, etc. We are really grateful for your participation. But how do we implement after we review our progress? During this process, in addition to maybe public consultations, NGO consultations, and mainstreaming advocacy, there's one issue that is we need to review. Based on Article 16 of the Climate Change Response Act, it needs to go back to the first one. That is, they need to set up their own goals and actions that's in line with the policy. So we are implementing first, but during review, we will need to also have a bottom-up approach. That is, each competent authorities, when they are looking at their key strategies, they also need to set up their strategies and their action plans. And during, so then all this would then be collected back to NDC for NDC to collect these information from the and through maybe public hearings and also through the community's mechanisms, we also hope that we can be in line with the regulations within the Aarhus Conventions, and that involves public participation. We'll try our best to work on it, but I think it relies on the public sectors to also take notice of this. But of course, we welcome also feedback from the private sectors and from the CSOs. Thank you. Commissioner Tian seems to want to respond to something, please. Yes, I know that domestication of the Aarhus Principle is not that easy, and it would not happen so fast. I think our representative from NDC just mentions that the Administrative Procedural Act, if it's based on the Administrative Procedure Act, then I say that please follow that act, because the Procedure Act is not about public hearings, it is about the hearing trials. It actually has a legal, because for public hearings, it's just that after people hear about it, then you just go back home. But if it's an official public hearing, that means that first your chair needs to be trained, and also you need to first identify the disputes from parties, and then out of the disputes, you need to discuss these different issues at hand. But that's nothing like the public hearings that we had in the past. Even as a legislator, I already objected it for a lot of times. So if we are to follow these procedure acts and have these hearing sessions and to start this negotiation process and had a communication with the public, then I would ask NDC to look into this and really follow the procedure required by the Administrative Procedure Act, because this is only the executive branch can follow the Administrative Procedure Act and have these type of meetings. And also, I had a look at the data and how typhoons have impacted our agriculture and produces, only looking at the agricultural losses. In 2020, the losses is less than 100 million NT dollars, but in 2021, it's already exceeds 200 million. In 2022, it's 140 million, whereas in 2023 is 290 million. And I had a 2.9 billion, and I look and currency this year we've already had over 6 billion agricultural losses. Now these agriculture accounts for less than 30. Our domestic agriculture accounts for less than 30% of our own demands. So this impacted a lot to our food safety issues, food security issues. Sorry. Thank you, Commissioner Tian. Also, just a reminder, actually, even though the administrative procedures look into as the official public hearings, but it's possible that they still use the public hearing process. But currently, many public hearings do not allow these general public to participate meaningfully. So it's not like public hearings is a no-go. It's just that currently, if it's possible, whether or not these public hearings are serving the function or the spirit of the Aarhus Principle, that's something that we can think about.
报告人简单回应。
So we will have Attorney Huang to to respond briefly. First of all, thank you to Commissioner Tian for your effort in advocating for making Aarhus Convention in a part of domestic law. And so the NGOs have been working on that for many years now. And Commissioner Tian, as a member of National Human Rights Commission, is saying that now it serves as a great significance. And Commissioner Tian's efforts in facilitating the Greenhouse Emission Reduction Act in 2015, that is the foundation of all of our discussion here today. And I want to go back to this 24 plus minus 1% by our two panelists. I understand that this number is a total of the targets willing to be put down by the multiple ministries. And indeed, we do calculate the effect of this number to calculate under carbon budget per capita. And from our calculation, this target is not effective enough. We would deplete all carbon budget of 1.5 degrees by before 2030. And we would also use up almost all the carbon budget of 83% of carbon budget using this target. So it also says that we would pass all the obligations to the future generations. That is why the NGOs are constantly saying that this target is not sufficient. And the examples in China and Thailand, the panelists say that our target compared to China and Thailand is not so bad, but these are developing countries, so it's not suitable for us to compare the targets with them. And Deputy Director General talked about the targets in Japan and Korea. It shows that Japan's example is more progressive or ambitious than ours. But I think the Korean case is just a matter of calculation, because the reduction targets of Korea by 2030, the base year is 2018. If we convert this using the same base year as Korea, we need to reduce by 36%. So that's a matter of calculation and having different formulas. The formulas or the calculation of NGOs and the Ministry of Environment have different results because we use different base years. However, we are delighted to hear from Deputy Director General saying that this number will be increased. Indeed, Director General also talked about that we need to reduce by 40% by 2032. So if we can achieve this target, I'm sure that the national reduction target will be greatly increased by 2035. We hope that with the increased targets and the sectoral targets, we can have concrete practices and that can really have concrete results. And I totally agree with Mr. Zhang saying that just transition is not the responsibility of individual ministries. From the perspective of the NDC, as a sole competent authority, that is not consistent with the spirit of having a bottom-up approach of just transition. So I totally agree that we need to have different ministries involved. For urban planning or for renewable power generation, and we need to ensure just transition in all these different progress and projects, and that's how we can follow human rights towards net zero. So I look forward to NDC urging ministries to put just transition into every piece of policy, and that wraps up my response. Thank you.
好，我们去。
Thank you. We have 10 minutes before the session ends. I'm sure we have more. Our panelists want to have more to say, but we want to ensure public participation. So we now open to the floor for your responses or questions. Or do you have anything you want to dig deeper into? Do we have any questions from the floor?
就那个，如果要
If we want to advocate for procedural rights, we need to really enforce or to make use of our procedural rights. So please feel free to ask all of your questions. We have one over there. Thank you to our presenter and the panelists. My question is that the head of NDC mentions that the ministries implementing programs and policies, and they now begin to focus on just transition. So the question is that which ministries already have actions or policies on just transition? And when the NDC urges the ministries to take actions, which areas would the NDC focus on? Okay, so we have one question. We will collect another one before we have our panelists to answer. If we have no questions from the floor, I want to ask my own question. Okay, I want to add one question addressing Mr. Zhang and Mr. Huang. We talked about how to set national reduction targets, and the NDC has their own versions. And the third-tier ministries, the Ministry of Environment, is also in charge of setting targets. So my question is that for the next phase of the policy of setting the next phase of national reduction targets, what are the roles that the NDC and the Ministry of Environment play respectively? And what's their planning for procedural participation? Now we have two questions, so we will invite Mr. Zhang to answer the first one. Thank you to our audience member for your question. The NDC in formulating plans for just transition among the 12 strategies, the ministries do come up with measures, but such measures would respond to their roles in the 12 strategies. So currently, such measures are more fragmented and quite dispersed, and they have allocated budgets to implement those measures. However, we observe that such fragmented approach failed to meet the regulations of Article 46 of Climate Change Response Act. So we are now requiring the ministries to review the current action plans and strategies to ensure just transition, or at least integrating just transition in their policies. And all these ministries would also have to discuss with the Just Transition Committee and to discuss in implementation. There should be a comprehensive planning on just transition and a communication with the general public. And according to Article 46-2 of the Climate Change Response Act, the NDC, with the help of Just Transition Committee, with interaction and communication with the general public, we would report the results to the Executive Yuan before we finalize the programs and to publicize it. So that's the work undergoing at the moment. And procedurally speaking, they're just all these are under discussion, so I don't know the specific date of such implementation. Indeed, we would want to have all these strategies and policies made public, and we will try to publicize them promptly. And there's a brief response to Commissioner Tian talking about the Administrative Procedure Act, because we were talking about public hearing. And if we want to have a legal hearing, we need to be in accordance with the Ministry of Justice in their implementation. But coming back to just transition or to all these targets, we will follow the public hearing, and we want to fulfill the spirit of Aarhus Convention. That would be our goal here in this area. And the design of just transition by NDC, how to balance, how to ensure that we leave no one behind. So from the NDC, in our guidelines, we would have the ministry's mid and long-term plans, and we can have them set up articles ensuring just transition that follows our guidelines. And we are formulating the guidelines at the moment. We also want to identify stakeholders and to improve our just transition policies. Also, we have several goals. First, we want to ensure the mutual benefits of the individuals and the industries. And for the net zero mechanism, we want to ensure consultation and support, subsidies, etc. So we are not looking at a specific topic. We would look at this more comprehensively. For example, in the afternoon, we'll talk about PVs at the Qigu project. I would want to ensure that just transition is incorporated in this. And perhaps we would promote regional governance sandbox to come up with more innovative solutions. And we also would have this deliberative or participation of public governance. So we want to invite the general public to have more people or local communities being involved in the entire process. We want to have more opportunities for the local public to express their opinions. However, for the target setting, we need to go back to the Climate Change Response Act. And we would also, so the NDC will play the role of policy research and to give better support to our cause. So that's the perspective from the NDC. My response is that for target setting, we will follow the rules of Climate Change Response Act. So the competent authority will be the Ministry of Environment. But we need to think about the coordination among different ministries. So previously, during President Tsai's administration, the NDC, the chair of the NDC, Mr. Gong, was also the executive director of the Sustainability Committee. He was in charge of coordinating and promoting the 12 strategies. And since President Lai enters office, he instructs the minister and deputy minister of the environment to serve as the convener of the Sustainability and Climate Change Task Force. So the effect would be stronger in this administration. And then the target setting will still be the task of the Ministry of Environment. And we do have more ambitious goals that the ministries may find difficult to achieve or to have their own ideas. But we are more inclined to follow the decisions of the Ministry of Environment, so we will continue to look forward to the end result of the target setting. And want to respond to the carbon budget per capita presented by Attorney Huang. To my understanding, it started out since 1997, the Kyoto Protocol. At that time, there were more than 300 items of how to set targets. So there are multiple having carbon budget targets per capita. But I find several problems with setting targets per capita. Currently, there are two largest emitting countries.
Take China, 30% of the greenhouse gas is emitted by them, but it is #1 in the world, but the per capita is lower than us. India, third largest, is also lower than ours. So if you look at per capita, the risk is that the global gas emissions will continue to increase. This would mean that greenhouse gas emission, once they're emitted, they will continue to be in the air, not just 1 day or 2 days. They will continue to stay for hundreds or even thousands of years. According to scientific evidence, 25% of the CO2 emitted would stay in the air permanently. So if we look at the per capita, yes, it is safe on one hand, but it is fair on one hand, but for the environment, it may even pose a greater risk, especially to the greatest two emitters, China and India. That's the argument from China. China is saying that we will need to continue our economic development, so we will only increase our carbon peak by 2030. So we will not be able to achieve net zero by 2050. We will only achieve that by 2060. Each country has its unique situation, and it's difficult for all those countries to have these emissions. All we're thinking is to think about what's best for the environment. All right, because of time, I will have to end this session. Last, just to briefly respond. Actually, this forum follow on the discussions of the Aarhus Principle and also the sharings that we just heard. I think there is one thing, actually two things very important. First of all, when we are promoting net zero policies, including setting up the targets, how to set the targets, we often have these different standards, these different comparisons. But when we're comparing and setting these criteria, are we really putting it in a human rights perspective? I think that's something that we need to think about, be it per capita or performing better than neighboring countries. The actual issue is that the potential targets that we may achieve, what human rights would be impacted under this situation. I think we're able to put on the human rights lens when we look at these issues in implementing and promoting relevant policies. Secondly, I would also like to thank our three panelists for spending a lot of time and reminding us. I think there's one thing that is very important, and I think that's the work for all of us. Procedural human rights and legal procedures have always been there. But are we really implementing the spirits behind these procedural human rights, be it public hearings or legal procedures or legal hearings? I mean, yes, public hearings can still achieve notifications in advance, meaningful and effective participation, and actually having an impact on the policies. But to what extent are we implementing these public hearings? Or to some extent, maybe competent authorities just want to go through these procedures without thinking about how meaningful or how effective these are. All I'm saying is that if we are, or if we need to go through the procedures anyways, in order to make it more, maybe we need to spend the energy anyways, then why don't we make it more meaningful? Once again, thank you, the presenters and our panelists. All right. Thank you, our moderators, our presenters, and our panelists. This sums up our session. Next, we will have a lunch break. Just a reminder, outside the venue, we provide lunch box, and we can eat in this venue. So please take a lunch box. It is an iron lunch box. It is made of iron. So after you finish, please remember to recycle. Put your utensils along with your food waste inside the box and return it to our organizers. Also, please be careful, otherwise it may drop to the floor. Also, just a reminder, please do not open the door of the balcony. Don't turn on it, otherwise the siren would go off. The alarm will go off. We will have the lunch session until 1:15.
好，那欢迎
Welcome back to the afternoon session of our forum. So we will begin the panel discussion on topic 2, human-oriented urban planning adaptation. Let's a round of applause for the moderator of this session, Commissioner Ye Yijing of National Human Rights Commission.
谢谢。
Thank you all. For this afternoon, I have asked that we must have coffee for the afternoon break because the morning session already used up the coffee that was available outside, and we'll have new refreshments in the afternoon. So thank you for your efforts coming here. And the morning session, we heard from Professor Schomerus, and I want to have a brief response on behalf of Taiwan first. If my memory serves me right, in terms of the EU, the UK has their domestic energy supply of 55% and 50% and 40 above in European countries, but Taiwan, we only supply around 4% of our own energy. We cannot generate as much power like Germany and France, or to import from as close as Russia and natural gas directly from Russia. We need to have imported energy supply, or nuclear in France. All of the power grids are all connected, but Taiwan is really isolated from everywhere else. So I want to have this plea that we are sparing no effort, and it's really such a challenge for us to reduce carbon emission. We are not a member of the UN, but we want to follow suit in any issues that are beneficial to human rights, to the environment. We are imposing self-regulations, keeping up with the international trends, even without any requirement from the UN system. So we must applaud our government, we must applaud our public sector. Not to me, to all of us here. Next, going back to my primary role, people may see me as a fierce person, I know that, may be confrontational, but I still feel like we must say those that must be said. So I first plead for the public sector, and I will move on to the harsher words or more serious topics. In the morning session, our Deputy Director General Huang from the Ministry of Environment says that setting targets is not enough. We really need to implement practices to fulfill those targets. That's what matters most. And I also talked with the head of NDC in the morning as well. I said to him that we would always want to keep up with the steps of the examples elsewhere whenever we hear anything. But for the targets of net zero by 2050, the targets we set for buildings and land use was, and the target is for net zero by 2050. I was so impressed. I felt like that was the first lead, that was really leading in the world, because all targets in the world are 2080, net zero of buildings and land use by 2080. And so we have even more ambitious goals compared to international standards. And I was saying that I told the competent authorities that, wow, you set ambitious goals. And they said, no, the NDC set this for us. So I addressed that to the head of NDC in the morning, and he said that indeed the target we set prior was a little bit put there in place in haste. So I want to say, what I want to say is that we need to set practical, achievable goals so that it's not just for show. So for this session, I want to talk about the things that the public sector needs to work on, the government needs to continue to work on. We have representatives from the NDC and the Ministry of Environment, but we don't have representatives from the Ministry of Economic Affairs. But I do find that lateral communication across different agencies matters. We need to incorporate multiple regulations and ministries on the environment. Even though the Ministry of the Environment is a competent authority, other ministries need to collaborate and coordinate as well. But in the current situation, multiple agencies or ministries seems to be compelled by the Ministry of Environment. I studied in Europe, so I was happy to speak with Professor Schomerus in German. I feel like my German is more fluent than the ITO representative's Chinese in the morning. But I'm very grateful for the European Union because the EU's carbon emission accounts for 7% worldwide. But most regulations, methodology, and efforts are led by the EU. And that's also because even though they only have 7% of carbon emission, but the EU is impacted drastically by climate change, just as anywhere else in the world, because we all live on the same planet. We see the floods in Spain this year as an example, so no one can be left out of the impact of climate change, whether you're in Europe or Asia or anywhere else. So we all must put in effort, but we shouldn't boast about our efforts. We need to really implement or take tangible steps. So here's a critique for the public sector once again, sorry. There is no concrete actions from the government. Actually, we see the private sector and the civil society doing more in tangible measures. Because we are an island and we must be implemented in the global economy, we need to export. And that is why the industry or the Ministry of Economic Affairs were forced to take actions. So we are forced to take actions. I feel like the Ministry of Fiscal Affairs actually has done well under such a pressure. Many financial institutions for reinsurance, for the financial systems, communication worldwide, the institutions must comply with all the principles and standards in the international community led by the UK, for example. Once again, another critique for Taiwan. Here's an example. I need 2 minutes. The Ministry of Economic Affairs to have green energy for the industry. That is why the ministry was starting to develop renewable energy and green energy. And without the DPP, there is no, we cannot make it happen. But the Ministry of Economic Affairs only focuses on green energy without the implication on people. For example, the PV panel affecting neighboring communities, especially Aboriginal communities. And they didn't think about how it's going to impact neighboring communities or how to dispose the waste of the panels. Even though the ministry allocated a budget to dispose of the retired panels, but the budget is used absurdly to having the companies, the private companies, to give back a certain amount of money after they receive the money in the first place. So it's really difficult to implement. So in the past 3 years, we learned that the current situation, the current situation is not practical. So and they are only taking amended programs now, having the private companies to commit to the fees for the next 10 years first and to pay upfront. So the ministries should think ahead to think about the practical implementations, and we should be human-oriented. And the Ministry of the Interior setting a goal of achieving net zero by 2050. It's already not possible. And now the Ministry of the Interior is not saying net zero, is approaching zero, because the pronunciation is similar in Chinese. So the approaching zero is that here's passive design of the architectural buildings and effective and efficient utilization of equipment, and to introduce smart control and power integration and development of clean energy that follows BEMS standards. So all of these measures can help us heading towards zero emission, but not net zero, but just heading towards. And so we will approach heading towards near zero, and saying to achieve 85% of all buildings across Taiwan would be nearly net zero. And how to achieve that? And what about the 15% left? Let's say that one day, all of your buildings, all of the buildings that we live in Taiwan, 85% of them have all these smart technologies that are nearly a net zero emission. But what about the rest of the 15% of the residents of the old buildings that may be hot and humid and without AC or terrible conditions? We should not leave them behind. The government should take practical, tangible measures to allot budget to think about all these disadvantaged groups that may be impacted by these policies. We need to think about their situations first before we take actions, and whether the actions are by penalty or by subsidies, but we need to first think about the disadvantaged groups. We need to ensure their rights. We need to ensure a just transition. It shouldn't just be a slogan. That should be something to be implemented. And I think that also responds to the morning session discussions, and that will be the spirit throughout the entire forum. So I will, we have members of the society, the presenter of this session would be Attorney Guo Hongyi, Secretary General of Environmental Jurists Association. Let's a round of applause for Mr. Guo. Moderator, distinguished guests, ladies and gentlemen, good afternoon. I am the Secretary General of Environmental Jurists Association, and today I will present on this topic, human-oriented urban planning adaptation. I have thought long and hard on this topic. What does it mean by human-oriented? In English, we said human rights-based or human-oriented or based on human. So there are all these different translations or interpretations. And is it an approach? Is it a solution? To me, I wonder for a long time. It's quite confusing for me. So when I respond to the organizers, I said that my topic would be a nature-based solution. And that is quite a mature concept in addressing climate change. So we will talk about the conflicts or non-conflicts between a nature-based solution and human-oriented solution. And then urban planning and urban planning adaptation. I was confused and tormented on these terms as well.
Urban.
Because we oftentimes use urban or planning, etc. But for urban planning in Taiwan, urban planning is actually a term. So it's difficult for us to use the word urban planning to include all those plannings regarding land use. That's why I changed to a different wording, which is land use planning instead of urban planning. I hope that while using these consistent words, it will let people know that be it the urban or cities that we're talking about, it's not limited to the urban planning act, the terminology under the Urban Planning Act. I'm talking about the governance of a city or the concept and the development of a city and how do we apply these nature-based solutions to the land use division. So basically, currently, what we have already developed is that what we need to do is to reconnect with the nature. We need to coexist in harmony with the nature. So when we talk about environmental rights, the UN already regulates and conceptualizes the concept of environmental rights. It can also cover the right to survival that is protected under the Constitution. ICCPR and ICESCR also talk about sustainable environment, all these links to human rights issues. So today, especially under the framework of climate change, environmental rights and human rights are closely connected, and that is something already established, especially when environment is actually become a human rights protections. In the past, it was the relationship between indigenous communities and their land, and now it's further expanded to the people living on the land and their relationship with the land. So for this part, I want to talk about the role of the cities. First of all, this is a topic that was given, so that's why I need to talk about this. But this is the three framework that I want to talk about. First, I want to talk about urban governance. When we talk about urban governance, there would be two impacts. First is urbanization as an issue. During urbanization, we may bring to all these disadvantages. And also at the same time, under climate change, what's the environmental impact it has on a city? And compounding these two issues, why is it we need to face these situations in a nature-based solution? Secondly, I will talk about nature-based solutions, and this would be the core that I want to talk about. Last but not least, I will also talk about land use planning. Be it urban planning or land use planning, when we're doing any type of spatial planning, it itself is a way to practice climate adaptations or implement human rights. First, I would like to talk about the importance of cities. People may think that cities cannot be connected to nature. However, cities are exactly located within the environment. We're not able to exclude cities outside of nature environment. More importantly, cities is an important hub between human beings and the nature, because we live within the cities. The developments currently we see now is that you feel that human beings live inside the city. If you see any wild animals, you will feel that it's like an animal formula. You see something that's similar to a Zootopia, but it's not like that. We need to look at it in a wider landscape, and let's look at the different aspects of an urban governance. First, it's a population within the city. A city is a populated area. It is a place where people mostly live in and also go to school too. So it is a place where the community gathers. Secondly, a city provides economic activities for people to get jobs, and there are relevant regulations that governs these economic developments. Also, within the city, we need to have environments. It includes the preservation of ecologies and cultural heritage. Fourthly, land use. In terms of land use, the moderator specifically mentioned that the regulations on buildings, on green buildings. Green buildings are regulated under the regulations regarding constructions and buildings. But for land use, it has this National Land Use Act, Urban Planning Act, etc. All these special planning-related regulations that can be a blueprint for land use. Next, transportation. Within the city, for instance, it may be a Taipei Metro Station, a Taipei Metro Station Company, etc. It may has its planning regarding transportation, but in terms of traffic, it also has a cross-country or cross-county planning. So if you look at all these factors individually, it may be something that an individual cities or counties need to face with. It also includes, for instance, infrastructure such as waste handlement or other things. All this will be included within the scope of urban governance. More importantly, within all these things that I just mentioned, we need to have land for these different purposes. I think most importantly, out of all these things, a basic framework comes from the regulations that governs the planning. Through these regulations, we allow each of these different functions has its own land use accordingly. But if we look further, this also means that we need to solve the consequences of urbanization. So these are some of the issues that comes with urbanization. First, there are more and more people gatherings. The population becomes denser and denser. So since these places provide a lot of opportunities, people gather to these cities. Another problem that comes with this dense population, it means that the land per capita would be smaller and smaller. A land I can live with becomes smaller. So take Taipei City, for example. With the same amount of price, you would only be able to buy a very small amount of land or rent a small apartment. And also the expansion of a city. So this means that with a city continues to grow, the city will expand to other areas. And this may impact, for instance, development of the environment. We need more land for people to live in or for industrial to develop. And it also comes with, for instance, waste disposal and other disposal systems. There are also problems that comes with this. And then with more population, we also means that the resources will get scarcer. The supply of food, the supply of land, the supply of residential areas, or anything related to human beings living in these areas have to do with resources. Also, with population comes pollution. You start to see, be it economic pollutions, industrial pollutions, or just the waste coming from the place that we live in, or the wastewater that we dispose every day. And then, of course, there may be ecological destruction because we are fighting lands against the nature, and they may hurt or damage the habitat of animals and plants. Under this backdrop, this is the existing issues of an urban place. Coming next to it, in terms of the climate adaptation, I won't look at the mitigation part of climate change because we're looking at adaptations. So what's related to urban governance is, for instance, the long-term climate events. The rise of sea level may have an impact to us. For instance, we took some interns to the coastal area. A lot of the lands have already occupied by the ocean water. Some of the tombs have already been covered, and some land and also road have already been covered by ocean. All these are long-term issues. The rise of global temperatures, the heat island effect within the city, and the climate security issues. This is a gradual issue. So you gradually start to realize the differences within the city, but you wouldn't all of a sudden find that it's a crisis. But a short-term climate event will really let you feel the urgency. For instance, heavy rains, or for instance, droughts, storms, forest fires, etc. These would all of a sudden let you feel that there is this crisis coming or disaster coming. In summary, For urban planning, it involves a lot of different regulations. For a city planning, it involves not just the Urban Planning Act or relevant Spatial Planning Act. It also involves, for instance, water infrastructure. If you want to deal with wastewater within a city, how does it combine with other rivers? Or for waste disposals, what land needs to be used? Or if it's across county or cross city management, how does it the coordination needs to be? And how do we plan a green building? How do we plan the relevant environments? It involves many different regulations. Secondly, land use planning is a basic framework for city governance. With this framework, I know that what this land is for, what's the purpose of this land, but it doesn't mean that it would be limited to this set function or set purpose. When we're facing national land planning, we feel that once this land is being assigned as maybe an agricultural area or for a different area, then there's no possibility of future development. It shouldn't be this way. When we are planning a land use, the reason that we are designing the land in these different processes is because, for instance, the attributes of the land or the potential of the development of the land, these are why it is planned. And within this setting, with this, there'll be without violating the purposes, you will still be able to have some potential development. So, like I said, this is just a framework. It's not like you are completely limited within that framework. Next, coming back to a very important thing for city governance, that is, even for any administrative planning, if there's any administrative actions that say, for instance, administrative punishments or administrative contract, etc., within this administrative act, it is actually a practice for realizing and protecting fundamental human rights. So administrative actions is also a practice in protecting basic human rights. And this means that it still has this obligation of protecting basic human rights. This obligation may not necessarily be shown in the regulations, but it would be seen in, like I said, these different regulations may require them to exercise these functions, for instance, environmental protections, ecological preservations, etc. In these diverse and fragmented regulations, it shows that in terms of city governments, they still have these administrative obligations, so that when they're doing relevant plannings, they need to think about the protections of fundamental human rights. Coming up to the next concept. Next, let's jump out of this discussion and let's talk about a nature-based solution. Nature-based solution basically means, under the definition of International Union for Conservation of Nature, it means that it is a protection and sustainable management and restore nature or human-based ecological system actions. And these actions can effectively and flexibly respond to social challenges. Let's look at the term social challenges for once, and to provide human well-being and the benefits of biodiversity. So first, it is the existence of ecological systems. With the ecological systems, you are able to respond to social challenges and at the same time provide benefits for human beings' welfare and biodiversity. When we are not able to mitigate as fast as the trends with the crisis and disasters, what we want to focus on is how to adapt to these disasters. So all this will come back to the ecological system. How do we leverage these ecological systems to respond to these different social challenges? At the UN level, at the World Development Bank, it also proposed a similar definition regarding nature-based solutions. So you can also briefly look through it and see these different definitions. But I think it talks about the natural systems and sustainability, etc. So these are some important concepts included. First is sustainability. Second is protection, management, and restorations of the ecological system. Now, I won't go into these detailed definitions of protection, or management, or restorations, but I want to focus on the term respond to social challenges. This includes the mitigation, adaptations to climate change.
只是它
And it's only a part of the things that we need to address. Let me repeat. Climate change is only a part of a nature-based solution, or one of the problems that nature-based solutions aim to solve. It's not the primary problem, just a part of it. Next, we also need to prevent disasters, reduce disasters in social and economic development, human health, food security, water security, and prevention of the loss of biodiversity because of biological degradation. So that should be a win-win situation for the human kinds and nature. And the UN has all these 8 principles and 28 indicators. We will quickly look at the 8 principles of NBS, nature-based solutions. First, it needs to effectively address social challenges, just as the topics that I mentioned. Secondly, the nature-based solution should be designed according to different scales. So the country government should have, the state government should have their own scale, local government should also have their different scales of nature-based solutions. And the NBS should bring a net growth in biodiversity and integrity of the ecological system. So we will talk about the false nature-based solutions, that is greenwashing. For example, introducing foreign species to restore a local ecology, or to plant a single species of woods to combat deforestation. All these are false NBS because they do not contribute to the integrity of the ecology. And next, the NBS should be economically feasible. Before we fulfill the goal of ensuring the integrity of the ecology, all of this needs to be feasible in terms of economy without restoring to the full states or completed states of the entire ecology. If all of these processes cannot be economically feasible, the measures would be put to a halt in the middle, and that would not serve our purpose. Next, NBS should have a governance process that's inclusive, transparent, and empowering. And the NBS also needs to balance between the primary goals and other benefits, and need to have adaptive management and evidence-based adaptive management, and to have a proper management methods. So among all these different methodologies of the ecology, there will be specific rules and indicators, and I will skip the details. And first, let's look at the examples. For example, in the Netherlands, returning water resource back to the rivers and to have a fluid city. And another example would be a Stuttgart in Germany, the Green Corridor. And the next example would be in Philadelphia of the US, a green city, clean energy. And a fourth example would be Highline Park in New York City. And that is a revitalization of an old train line and put it into a garden. So this example is Green Corridor in Stuttgart, Germany. So in this example, there is a corridor for the winds. So within such a space, there should not be any buildings or obstacles hindering the flow of winds. And Professor Xu is actually an expert in this, and he will respond to that because I also read that from his article. But for this example, with spatial planning and building restrictions and construction limitation, that can reduce the hot island effect within a city. So we will look at the land use to implement adaptation to climate change. First, we really need to have sufficient investigation and disclosure of the information on urban planning. Without investigation and disclosure, we cannot plan comprehensively. And also, we need to have flexibility in the land use. Indeed, for Stuttgart's example, there are restrictions of buildings within the space, but there is still a flexibility in place. And next, to set natural preserves, and that's a critical element of nature-based solutions. And next, we need to prioritize biodiversity in the entire ecological system. And next, for the national land project for Taiwan, so that would be a structure on the national level, and we go down, top down to the local levels, and even to the townships and city plannings. So we need to have this top-down planning framework, but for the implementation should be bottom-up. The local residents, the local communities, to really think about the plans possible for the local neighborhood, for the local environment, even though there is a plan framework top-down, but the local communities can come up with measures responding to these plans. I do not have a specific conclusion, is because the entire concept and the entire methodology are still under development. And we are also facing several issues. For example, in Taiwan, the land use of the rights owners may be in conflict with servicing the ecological system. So there is a social obligation to the right to property. That is a little bit troubling for those who feel like, oh, I have the land right, then I can use it however I want. The connection between your piece of land and other pieces of land, there should be this obligation, this social obligation. And it's even protected or stated in the Constitution and existing laws that there is a relationship between a piece of property and other properties. So we really need to think about this a neighboring relationship. And also there is a standstill of the land use projects in Taiwan. We have all these different goals in the National Land Project, but the law cannot be implemented. And that's because multiple reasons proposed by the legislators that the title of the land use cannot be altered or cannot be changed. When a piece of farmland is changed to other land use, if we cannot change the land use, people, the rights owners, will feel like their rights or freedoms are damaged or harmed. For a piece of land, agricultural land cannot be converted to else use, they would demand compensation from the government. And that's why the national plan cannot be implemented. And next, the local government's response to extreme weather conditions or incidents, we really need to think about the government's duty and obligation to protect human rights. Some say that the government has already done so much, for example, installing all these retained pools to address or to prevent floods, but there's still a lot of floods. So it doesn't mean that the government is not doing enough. We need to really think about that. And then we also need to consider a balance between multiple interests in the urban planning system. We need to have full information disclosure. We need to have full participation throughout the entire procedure. It's not just one single interest or stakeholder should be taken into consideration. We need to have multiple stakeholders involved. So all of these are the conclusions, and that wraps up my presentation. Thank you. Thank you to Attorney Guo for his brilliant presentation. And next, we will invite Commissioner Ye on stage to introduce our panelists. So the next speaker would be Professor Shi Wanyu of National Taiwan University, who has extensive research on resilience and climate change adaptation. While the government in Taiwan feel like they have done so much. But because Taiwan is an island located in the middle of the ocean, being very sensitive to changes to the oceanic environment due to our geolocation, we already have allotted a lot of budget to prevent disasters, to prevent natural disasters. However, are such budgets efficient to respond to extreme weather conditions? And so Professor Xu will talk about the resilience or climate resilience. Let's welcome Professor Xu.
好，谢谢叶委员的。
Thank you, Commissioner Ye. Distinguished guests, dear organizers, thank you for inviting me. I'm honored to share with you the human-oriented or human-based urban planning adaptation. Upon receiving such an assignment, I felt that the entire dialogue on climate governance and net zero and climate change, I was thinking about how to frame everything together in my presentation. And then I wanted to focus on IPCC AR6, the 6th assessment report, and list all of these adaptation issues concerning people, especially within urban cities, and all these aspects. And I will present that or have a dialogue with you from this frame. First, just to ask, we've all heard today that even though the effectiveness of net zero is not sufficient enough or fast enough, but under extreme conditions or extreme examples, we often see that in recent years or in recent days, there are incidents with temperature rise of more than 1.5 degrees, and all these different incidents happening around us. In the past, we only talk about incidents in developing countries, but we recently found that in developed countries, whether it's European countries or the US, in the past we thought that their economic development has achieved to a certain level. They may be more willing to adapt to climate change. However, we find in recent examples that these developed countries don't have sufficient capacity in addressing climate or extreme weather conditions or such incidents. So it taught us that Taiwan needs to be better prepared to respond to those incidents. So this example comes from Florida of the US. In the year 2020, there was a Hurricane Ian attacked Florida. And that responds to IPCC AR6, the second report stating that more and more cities are exposed to high risk of extreme weather. And in the past, we didn't realize that, and urban planning comes even without our awareness of extreme weather conditions or climate change. Even up until today, we have not identified all these different areas that have higher risk being exposed to extreme weather. And we always want to have more local development and infrastructure. And so looking at this example in Florida with such a drastic loss of life and property by Hurricane Ian, the reason is because that since 1970s, the residential areas were limited and the population was limited. But until 2020, development has expanded across the coastline, and all these areas are cyclone prone in the riverbanks as well. So when we bring more and more people living in these risky areas without even thinking about how to address or to prevent disasters and to have more resilience, to have all these houses so close to the beach and without any buffer area, that has caused to such lots of injuries and death by hurricane. And this is already happening. In the future, it will happen again. How about Taiwan? We're bound to face that, but we don't know yet where that would take place. Are we taking more people into these high-risk areas? I feel like it's possible that it's happening now, and we are allowing it to continue to happen without any solutions.
另外一个
Another important issue is that this report talks about one term. It's called inappropriate or improper adaptation. I think in a comparatively developed country or a city, it needs to come back and look at this issue. Especially in Taiwan, we proud ourselves to be having a good democracy and a good economic development. But looking at our urban development process, many of the approaches based on the current and modern perspective, if we look at climate change or fairness or justice in mind, we found that there are a lot of lessons we can learn from, so that our society can be a fairer society. The first thing is the land use policy in order to prevent disasters or in order to develop the cities, since they need space, so we will move things that we don't want to. We sacrifice the disadvantaged groups. When we need land, we also go to the less economic developed place or disadvantaged group. Take Taipei, for example. The development of Taipei actually, in the past, we look at it at a confrontational manner to face the rivers, because we want to be able to maintain the floods, because Taipei is a basin. So Professor Liao mentioned this a lot, and I also referred to some of the cases that the professor referred to. So when we are trying to maintain these floods, we have these flood retention measures. So this is Danshui River and Hesui River. In the past, for Sezi Dao, Sanchong, and Wugu and Taishan area, in the past they are wetlands. And they are also in the downstream area, so it is easier for them to be flooded. But in order to protect places with higher economic developments in the Taipei city areas, so we built a lot of embankments and dikes. And when these dikes are built, even though the dikes are heightened along the way, and the other places, of course, can now be urbanized. But in the past, during this process, we were trying to maintain the floods. When we are trying to build a channel for the floods, we sacrificed many residents living nearby. They live near in the rural area, and since they are managed, they need to, in order to protect the upstream region where they have higher economic developments, they have to burden the floods. So their land needs to be taken away by the government. But even to this day, we still do things like that. We want to protect economic development. So for some places where floods are prone to happen, we want to direct the floods to other areas where they are less developed. But it doesn't mean that those areas do not have any residents. So those people will be sacrificed. If we continue to adopt the same approach, it would not be something called adaptation. Under this framework, it would be called improper or inappropriate adaptation, because we protect ourselves while sacrificing others. So what happened is that in order to have a place, in order to build a channel of a floodway, there are a lot of forced eviction cases. Now, of course, back then with the authoritarian regime, so the approach would be more extreme. So that also came to the first protest case. Another thing happened to a developed country. This is proposed by a scholar. This is the term called green climate we feel that this is this is actually a process that is good for the environment, and so we call it a green climate gentrification. But nature-based solution should be a solution. It shouldn't be something that creates new problems. So what you need to focus on is not just the ecology, but also economic development, and at the same time, human issues. So if we fail to respond to all three different aspects, it would not satisfy the definitions of nature-based solution. So what it means by that is that, for instance, in Boston, we see it as a flagship green foundation, green base. So it actually finds a lot of places as a green base, and it also developed the area along the river. For instance, you have these grassland and greenland. You have built this network along the way. But in order to do so, the consequences is that the disadvantaged groups living along the coast were forced to be evicted because these lands need to be given back to the ocean, so they face forced evictions. Does this also happen in Taiwan? What we need to be very careful is that maybe take Taipei, for example. This is also what Professor Liao mentioned. I try to look at it from a different perspective. If we call this place ecological Sezi Island. Now, Sezi wetland. From an ecological perspective, we feel that it's good. It seems to be good for the environment. It provides a lot of environmental benefits, and future generations may also have more economic development and more potential in this area. This would potentially solve the consequences led by the past wrongs. But the way we develop it, even though it is of good intention, but in execution, it use zonal expropriation. Expropriation means zonal expropriation may means that the developments would happen while cleaning a development, and that would decouple the connection that people has with the land, and also make the social resilience disappear. So this is not a nature-based solution. This, I would say, is still an improper adaptation. Another thing is the risk of high temperature. This is rarely talked about. During urbanization, in some areas it would be hotter than other areas. Well, even though we are all impacted by the urbanization. But if we look at it, we find that global warming, the level of warming is not even. Some are cooler, some are hotter. And this has to do with our land use strategies. From some areas, they have fewer grassland or greenland, and also it's because of the overall ecological environment. For instance, is it along the coast, or are there factories nearby? Are there rivers nearby or mountains nearby? Now, this would cause these uneven temperatures. Now, this is also linked to the social and economic status. Sometimes that would make the less disadvantaged even more disadvantaged. So these less advantaged groups are then exposed to high temperatures, and they get hotter weathers in summer, and they don't have green land to adapt to these environments. And if they need to turn on the AC, because of economic pressure, they are unwilling to turn on the AC because they have to pay the bill. Even though there's no isolations of the races in Taiwan, but what we still see is that in some areas they're exposed to higher temperature, and these people may be people of the less advantaged group. Then we need to look at the problem of energy poverty. Another thing is my recent research. high temperature is also linked to urbanization, but urbanization is still more development oriented. We already know that Taipei is already hot enough, but if you look at the development in the past decade, all the rivers in Taipei, Danshui River, Keelung River, and the coast and the banks of river, and it also links to Linkou and Chaoyuan, all these areas, there are so many different developments happening. Also, under the Spatial Planning Act, they are all listed as an urban planning areas. This means that they will become hotter and hotter in the future, and that also would link with the flow of the wind. So we've always imagined that with wind, things will be cooler. However, the problem is that sometimes the wind will only make things hotter because the heat would be emitted to other places along with the wind, and that wind would lead to higher temperature. I have 30 seconds left. I want to come back to the IPCC report. It focuses on during the resilient needs to ensure procedural justice, distributional justice, and also we need to recognize these different knowledge and perspectives. All these need to be included in our policies. In the past, we said that we need to share the benefits, but in the future, with extreme conditions, we need to not only share the results, but also share the burden. And I know that there are a lot of people with the legal background here with us. We need to think about this together, because if we want to protect the environments or protect the land, we may have property issues. But if this land is actually for the adaptation of climate change, is it possible that we can also solve these confrontation between ecological developments and developments? Can we maybe design a policy, a land use policy, to respond to the fact that when we're sacrificing the interest of individuals, it is actually to provide the services of ecological system? Can we actually design some land tools or instruments, be it some of the tools for urban planning or for other possibilities? Is it possible that through this legal framework we can actually design some tools that can adapt better to the nature? That's it for my presentation. Thank you. Thank you, Associate Professor, for the wonderful presentation. Because of time constraints, I would then like to invite the last speaker of our session, Deputy DG of National Land Management Agency of the Ministry of the Interior, Xu Yanxin. Commissioner Ye, originally the organizer invited me and gave me this topic, but I thought it's going to be an academic discussion, but I was quite nervous. But Commissioner Ye also gave me a recommendation. Well, from an academic perspective, there are some possibilities for the urban planning for net zero, but this topic is about the human-oriented urban planning adaptation. So a lot of people use AI, right? So I asked them what Taiwan looks like with AI. AI tells me that with urban planning, the city needs to look like this. It's not about Greenland. It has nothing to do with human rights. That's what AI thinks about urban cities. So this is what I want to talk about, the planning mechanism of post-colonialism. So we bring these concepts of planning, we borrow the concept of planning, because if we have a vision, if we have a shared perspective, and then it's turned into regulations, then it will not be so far away from us. So that's a very odd situation. And post-colonialism allows us to think that, oh, we can't just go to the other countries and advanced countries and say that we also want to look like that. So that's the first thing I want to talk about. The second thing is that when we talk about climate governance, what does governance mean? Otherwise, we will go to a post-colonialism again. But because of time constraints, I think coming back to my own business, I will want to talk about when urban planning and how does it couples with climate governance? Because ultimately, we still need to have a plan so that we know what to implement. Otherwise, all these are just slogans and concepts.
So I'll be very brief. If we have time to interact in the future, we'll have more discussion. So let's go into the first part. So what is governance? We can talk about plans as well. In our expertise, the concept of a plan should have the values, the visions, and then going down, you need to have all these functions and departments and spatial relations and social relations. I put a dash in spatial relations and social relations because currently we don't have that. If we do, we don't need to discuss this. And going down to the plan, you need to implement the plans, and for the plans to be implemented, there may be a development plans and action plans. And for the plans, we need to have oversight as well. But currently, there is no oversight or accountability yet. And to come up with this climate governance and the core framework, I am a student of Foucault. I do agree with Foucault's argument, saying that governance, in comparison, should think about the subject, and that can be variable, and how we can identify with the subjects. And all the solutions that we come up with should be something that we all identify with. So to put plans into this framework, governance should be about how we make changes and how we make tangible changes. And we can formulate actions, give it social, from the civil society or private sector or the government. We should all think within this framework of governance and to make plans accordingly. So when we talk about climate governance and making plans, we need to think about how we view climate as a community, as a collective. What kind of aspects of climate are we thinking about? And we also need to look at the body politics of climate so that we can expand the effects. Some that you have, all you need to do is to propose a concept and people may agree with you, but some other people made other evidence for them to support or agree with you. And you need to present an experience. So I feel like climate governance should present a platform. The spatial planning should serve as a platform for this. And I also want to talk about, we have friends from Germany and Japan and US here, and we talk about the experience in the US and Japan and Germany as well, especially the example highlight of New York City. And in the concept of space or spatial planning, in Germany, there is a context. They started out in the reform in the Prussian era, and then moving to the modern time. So from this graph, we see Attorney Guo mentioned the example, the wind corridor of Stuttgart. And we look at the German law. They have all these different laws regulating farmland and infrastructure and land use and land planning, talking about the space order of national plans. And they have F plans and B plans. And with the context of Taiwan, we have major primary plans and detailed plans. But for the German example, the detailed plans, the B plans, are really, really specific. And I don't have time to talk about the landscape regulations or the landscape planning in Germany yet. That is a very local thing. in constructing a nation, constructing a country, and constructing an urban landscape, all of these are tied together, but I have no time to talk about that today. And so when we do land use, well, I have an animation here that I can't show you, but to briefly put the detailed plans in Germany, they are retrieved. All of the designs of the building are specified in the B plans, in the detailed plans. However, in Taiwan, the detailed plans only talk about the utilization of the building or the land or the functions, so there is no specific designs requested in the plans. So that's following the example of the East Coast of the US, and not even the West Coast of the US apply the same model, but I'll be brief here. This is in New York City. They have a historical context. They have a physical experience in developing cities like this, because New York City in the past had no such planning or regulations, and there are harm or hindrance of sunlight, of air, and then people formed a consensus on restricting the land use or zoning as a system in urban planning. And we follow that example because our scholars probably studied in the East Coast and then brought that model in, introduced that to Taiwan. So we use this land capacity regime in Taiwan. That's quite similar to zoning in New York City. So there are incentives in place. So you need to constantly incentivize the actors to follow the new policies of the government. It's not so whenever the government comes up with a new policy, they need to come up with new incentives to promote that. And that's seen in several cities, but not all cities across the world. And indeed, New York City still faces a lot of problems. For example, there are still critique on urban renewal in New York City, such as Jonathan Barnett. Scholars come up with urban design principles and urban design review. And here comes the example of Highline Park. And just as Professor Shi mentioned, this is rezoning. And rezoning, can we only translate that into Chinese as overall review? It should be equivalent of overall review in Taiwan's context. So rezoning is similar to B-plan in Germany, but with looser rules. But it has all these different purposes laid out. So Highline is the result of this new concept of rezoning, but currently that's not feasible in under Taiwan's current framework. And here's another example of Japan. That is the journey of Japan. This slide was taken from my teaching materials of the past, and that's a historical chart pre-World War II and until after the war. And after the war, before the war, Taiwan followed the Japanese model, but after the war, Taiwan's situation becomes different. But we still share similarity with Japan's development. So before 1990s, the development journey were pretty similar, but we diverged in 1990s. In Japan, there are two systems. In Japan, they have a comprehensive development of national lands and another strategy. And for Taiwan, we only have one approach. And in Japan, the national planning plans the use of lands. So there would be all these different projects of different electricity or transportation plants, etc. And throughout this process, there are issues in the cities as well. For example, have you heard of this word, community development? That it comes from environmental movement as well. And there resulted in 3 separate laws. One is Community or Development and Landscape Act and NGO Act. All these 3 separate laws stipulates that the development of a community needs to be decided by all participants of the community, and that would be referred in the development plan of the national lands. So there are 3 different tests. Community, NGO, and landscape all form the genealogy of Japan's community development. In Taiwan, there are community development as well since 1995, but there is no hard rules or regulations in place. And going back to Taiwan, land reform that is unique to Taiwan, unseen in Japan or US or Germany. The land reform in Germany was only about agricultural land, so that's different from Taiwan's land registration system. And in Taiwan, there are multiple factions of urban development or urban planning because of different schools and different trainings. And so I am only talking about a specific system or specific faction here. This scholar, Lu Yujun, studied in France, so his approach was not used in Taiwan, and his approach would be more similar to B-Plan in Germany. From here, we can see that there are critique to the modern life, and then there's zoning and laws in place. But that's on the left. It's the German example. And on the right-hand side, it's Taiwan's example. We have multiple factions. We have the modernity under Japanese colonial rule. We have the KMT land reform, and we have all these other factions as well. So it's really, really complicated. And I only have 2 minutes left, so I'll skip through them. And this year is the 60th anniversary of the implementation of urban planning laws in Taiwan. In the past, in China, there is a spatial governance plan in place 60 years ago. And the gentleman in the picture was a representative from the UN, and he was in charge of stipulating the laws then. And under the current framework, we have the national land plan, we have county and city land plans, and we have primary plans and detailed plans. But in German's example, all of these would be within the same single plan. And all of these different plans are integrated to different extents, so it's really complicated. From this slide, we see that urban planning and zoning and land development, we now have all these different relationships in terms of people, in terms of land, in terms of economy. Do we have all these different relationships laid out and have separate plans, or do we have a comprehensive plan in designating all these different areas? And which system does Taiwan adopt? The gentlemen in the pictures here are the Nobel Prize winners this year, and we have a choice here to there are multiple ways to skin a cat, but it just depends on the speed of achieving our goals. And just as Commissioner Ye mentioned, in terms of spatial development and planning, in terms of adaptation or carbon reduction, we only talk about green architecture or energy efficient labels. So going forward, we can only have nearly net zero buildings rather than having really net zero buildings. And the current system requires a lot of incentives on green architecture, on capacity, on energy reduction. All these are provided by incentives. And the graph here, the orange boxes and the green boxes refer to the existing existing laws and having new concepts in place. we need to incorporate net zero approaches into all the national land use plans. So how can we mend the gap between our systems and the examples elsewhere? Fortunately, Taiwan has really limited area, so the things we can make change very quickly. So the most important thing is to have digital information on national land in terms of climate change. We need to have climate change oriented digital information. If we can use that, we can turn all these different existing blocks, green blocks. Many in Taiwan, 82% of the buildings are completed. That is to say that all on the land that can build buildings, 82% are already completed.
The participation of the communities and the accountabilities needs to be involved. Otherwise, things will not be able to happen, because that's something that needs to be bottom up. So this sums up my presentation. What we need to think about is how to get to the next level, how to go to the other side. How do we do this step by step, phase by phase? Thank you. Thank you. Thank you, Deputy Director General, for the presentation. We will now go to the Q&A session. I would like to invite the moderator and also the panelists and presenters all to be on the stage. I would like to ask the moderator, Commissioner Ye, to moderate the Q&A session for us. Thank you. We have limited time, so please ask questions, especially Deputy DG do want to hear questions. Otherwise, it's like he's going to be questioned by me. All right, anyone? No questions? I'll start my questioning then. Really, we have limited time. Okay, we have one hand raised over there. Attorney Huang, please. Attorney Guo talked about we need to include people in one of the factors, or how is it, or it is that the cities and the humans are living together. We know that indigenous peoples knows best how to deal with the land and the nature. We often have cases, for instance, when there's landslides within a mountain. How do we restore the land? Indigenous peoples have their own ways, and the government, of course, have their own other ways, listening to the opinions of experts and scholars, etc. But when these approaches are in conflicts under the existing laws, how do we include the feedback or comments of the local communities? Because these people may even know better than the nature, know more about nature than us. How do we realize this in existing framework, or are there any possibilities within the existing legal framework? I want to ask all the presenters and panelists. All right, maybe as a moderator, what I know best is to translate the question. I will say that these are these are not colloquial enough. I'll try to make it simple. Let me give an example. Because of extreme climate change, it is possible that in Taiwan, for instance, we have landslide. And the indigenous peoples are really adapted to the nature. They feel that they have the right to and the ability to respond. But the government may feel that, oh, this is a very risky place. So they may evict these people. If I translate it wrong, please correct me if I'm wrong. So there will be forced evictions. Now, indigenous communities may then feel that I am limited or restricted by you, or I am overtly interrupted by you or intervened by you. Under these circumstances, are there any ways to guarantee the rights of indigenous peoples? That is, their rights, environmental rights, and their also residential and living rights. And how do we do this while also ensuring the resilience of the environment? Okay, maybe we can ask the government to respond then. Thank you, Commissioner Ye. Thank you, Attorney. If you look at the legal perspective, indigenous peoples, I should put it this way. I'm in special planning. What you talk about is actually about the relationship between special and also ecology and social and physical. What's lacking is understanding and planning from the indigenous communities. I think it's because the lack of accumulations of knowledge. There are, of course, a lot of planning, not a lot of research. Within the existing mechanisms, if they are living in the natural park or natural reserve, then we can look at the Special Planning Act. They can look at the, for instance, national park plannings. But without this concept, it's hard to be realized. And in Special Planning Act, they also have like urban or county plannings. We can do the planning together to understand. But of course, in the initial stage is to make available these informations and allow people to trust this information. Currently, we are using the disaster prevention systems. A lot of the information have already been made public. So we are already managing this. But if this level can have more planning and more resources so that they can be accumulated, be understood. Otherwise, of course, we would look at it the most conservative way and from imagination. So, of course, the right to life and also the right to culture would not be protected at the same time. All right, Attorney Guo also want to add something. Thank you, Attorney Huang, for the question. Just want to briefly respond. This actually depends on how do we ensure local knowledge can be included in this planning mechanism, especially when, for instance, we're talking about indigenous peoples. But globally, it's not just indigenous peoples, local communities, they have their existing knowledge. All those things are the resources they can provide to the planning agencies. For instance, the hunters in Ali Mountains, they know best, for instance, so if this water goes to these routes, that means that the land would be disrupted in the other areas. So this would prevent a landslide. But this knowledge was not accepted by the government. Said they've always known the construction agency and said that if they'll move next, that once there is rain, you will not be able to find your equipment. But of course, indeed, the landslide would happen. On some level, how do we allow local communities to be involved in this planning process and become part of the partners, especially the FPIC, FPIC system, to be realized not just to the indigenous peoples, but also to local communities? I think that's something that would be the easiest way to include the local knowledge in our planning mechanism. Any other questions? Okay, please. I would like to thank all four for your explanation. I want to include, I actually want to look at all of your presentation. The question I want to ask is that when we are facing extreme climate change, we know that a state actually has this 3D mapping regarding disaster potential, because in those we would see, for instance, floods and landslide, etc. But it is difficult for us it seems that the regulations do not require such disclosure, because, for instance, Japanese actually has detailed regulations that allows us to know that some of these lands are of high risk. The professor at National Taiwan University also mentioned that. So I want to know that in terms of responding to climate change, in the future, with ministries or government agencies, what collaborations or improvement can the government do? Okay, because of time constraint, we'll allow 3 questions only, so we've already asked 1 and 2 more maybe. My question is addressed to the Professor Shi and also Vice DG Shi. You talk about the heat island. You also talk about the wind corridor. My problem is that if this wind corridor requires a space, because the nature looks like that, you can't shape maybe a certain way so that the wind will be redirected. The wind will not be redirected, it will just go as the way it is. If we are dealing with a wind corridor, and if we want to maybe empty a place and reserve a place, but in the local communities they already have legal or illegal residents in this area, then what are the ways I can do to avoid the so-called inappropriate or improper adaptation, or let's say eviction? That's the first question. Second question is addressed to Vice DG Xu. Take Jiangzi Cui River and the high buildings along Jiangzi Cui. Jiangzi Cui in the past is a wide and spacious area, but now there are a lot of high buildings built. And you mentioned earlier that since this is a building that's already established and constructed, all you can do is to go to the most basic one, that is from the building community perspective, and to make things greener. I think it's a bit abstract. I did deal with some building cases. I want to know, how do we do this better? How do we do this green governance right? And would it be helpful for reducing the temperature within an urban? Or what are the ways to more effectively achieve this? Okay, these two questions are related. It involves the sensitivity or environment sensitivity area, but you talk about floods or landslides. They are already listed as already the sensitive area, but wind corridor is not yet listed as a sensitive area. So actually in our regulation, we have announced some of these environmental sensitive area, but this may not be be the same or in line with what's published by NCDR, because NCDR looks at different environments and what's the depth of the environment and all these risks of these land. So under these circumstances, is it possible that under different levels, we would need to maybe use the concepts of environment sensitive area and limit the use and purpose? We would need to think about, do we identify the risk and limit the developments? Who's the one to make such call? There may be some issue for that. The second thing is regarding the scenarios for future climate change. I think things would be even more complex because we still have the gap of adaptation. That is, globally, we are still working hard to bridge that gap, because if we are talking about adaptation, it's not just about exposure or about a certain type of climate disaster. We have to also look at the social and economic adaptations and the vulnerable groups. Once all those are identified, of course, all those things will be even more complex. So from the current status, when we are planning these land use, what we have been doing is that in different levels, when we are doing land planning, for instance, local special planning or urban planning, we will refer to them, but to what extent do we refer to them? Because referring to them doesn't mean that we will have to be limited by them unless they are already regulated, then they will go to a different track where the committee may propose such proposals. But proposing is one thing. Whether or not they would affect the decision is another thing. So all those are still just for reference at this stage. And in reality, in practice, urban planning does have this problem. For instance, if our urban planning committee members need to develop in a certain way or limit the developments, but at the same time it doesn't have a public announcement by the government say that this is something that cannot have any developments, then of course there may be protest by the general public. And I think that's the key. We do need a regulation to solve this, or a certain policy to solve this issue. As for the wind corridor issue, indeed, each city has this natural wind corridor. Normally, it's a lowland on the valley or along the river. All those are natural corridor. Once it's in the terrain, it's still going to the lower land. So I think it would not be the constructed area. It would be other surrounding area that would affect the features of the wind. For instance, along the coastal area, along the banks, or the valley, or some very important wind corridor entrance and exits. I think all those would be a very important place for the cities to breathe.
But in the past, Taiwan didn't have such information or knowledge. That is why with all these areas are filled with buildings now, and they are all private properties. And what we can do now is that for the areas that are still not developed yet, we want to preserve them as much as possible. And for the future possible areas for wind corridor that are more sensitive in the urban developing and the plans going forward, we can try to preserve these areas as much as possible. And we can follow example of Stuttgart. It's not a new city, newly developed city, but the city was developed ever since the World War II and in the 1980s, and it's still ongoing because it takes a long time to have this long-term metabolism of existing buildings. Before we retire old buildings, we need to first identify these sensitive areas or the areas that should be preserved. If we identify that in the future development plans, we can try to reserve the space for winds or for other purposes, and in future urban renewals we can come up with compensation schemes and to reserve the areas. Deputy DG, you are the representative of the Ministry of the Interior here today. So how can we amend the current regulations and to conduct green governance, especially for apartment buildings? So for apartment buildings, we are actually trying to formulate regulations and to have sufficient penalties and regulations on these apartment buildings. We want to follow the example of Japan, who has done extensively in this part. So we need to have the general public first have the experience and to have enough knowledge and information before we empower the general public. So we do really need a lot of sub-plans and projects. And we now are stipulating those plans for community development, for apartment buildings, etc. Here's a quick example. When I was in Taipei city government, we had this incentive project for communities to have all these different ideas on doing green, going green. So any so-called green concepts can be incentivized or subsidized. We do not know for sure that these innovative ideas would have tangible results, because at that time we didn't have the methodology yet. So we would use different technologies such as imagining the future using the AI or following the examples of Japan, Germany, and Denmark. With enough evidence from other countries and examples, we can formulate concrete plans, because we know for sure which methods are more effective. And if we can introduce enough examples into current discussions in Taiwan, we can move forward. So we need to accumulate a lot of know-how and information. And this wraps up our session. Thank you very much. So we will now have a 5-minute break. We will have a 5-minute break. Please come back at 2:53, and we have fresh coffee outside the venue. And here's a quick reminder that if you have not returned your lunch box, please please take it out of, to return it now. Thank you.
副连线要直接从人上来讲，是不是？
没有，等一下。
不好意思。
带他们上去，坐上去再介绍。所以就是报告人先上去，语谈人先上去。OK。
那就开始。
那是不是要跟他们两位讲一下？
他们是语坛人吗？
对，他们应该是两位语坛人。
那请他们等下再上来。
对。
然后就是谁的呢？
Is our third panel discussion. Topic: Green energy is good, but community participation is essential. Let's welcome the Professor Fu Lingjing, Chairperson of Environmental Rights Foundation, as the moderator for the session.
大家好。
Hello everyone, good afternoon. I am Fu Lingjing. I now teach at Zhengzhi University and I also serve as a chairperson of Environmental Rights Foundation. So welcome you all to participate in this forum and thank you for coming. Without further ado, we will go into the presentations of topic 3. Our topic is green energy is good, but community participation is essential. We have two presenters. One is Chen Yuping, Secretary General of Taiwan Environmental Planning Association, and we also have Director Wu Xingping of Homemakers United Foundation. And let's adjust the agenda a little bit because one of the presenters needs to go early. Oh, it's okay. Well, we'll go through with the original plan to have Ms. Chen present first, and then Ms. Wu will present later, if that's okay with you. Okay, so, we will invite Ms. Wu to speak first to meet your schedules. So please go right ahead. Thank you all. Today I'm honored to be a presenter here. Our topic is following human rights towards net zero, and we have multiple speakers talking about we need to have a human-based, a people-oriented approach, and we want to talk about civic electricity power generators. And there are multiple terms in English translation, but I find citizen power plants that is the most suitable in my presentation. So citizen power plant projects. So first, allow me to introduce our organization, Homemakers United Foundation. We started really early on since the martial law in Taiwan was lifted, and because Taiwan was under a long martial rule. And there are pollutions in the rice and grapes. There are incidents with toxic foods. So we have pioneers in this movement trying to boycott polluted products. And we started out communes, corporations, And that's how our foundation was started. And because we always give this introduction first, because people may ask that, oh, you sell organic foods, is that correct? But we are of a foundation that is an environmental group. But we have another group of pioneers that started out the corporation. They use the same name, but they sell produce products, and that's different because I come from the foundation side of the organization. And for our foundation, we have been involved in civic participation in communities, and that is a little bit different from other NGOs. So we emphasize the participation from bottom up. And you may know us from issues of food safety and energy transition. We started out advocating in civic power plants, citizen power plants in recent years, but we find that the concept now, or the mindset now, is not really citizen-oriented. And this picture taken from Guandu citizen power plant, that is the first in Taipei City to use the roof as to start a citizen power plants using public lands. Because in the past, if the government wants to conduct solar power panel projects, they always commission large companies to have a large pieces of land to have these solar panel farms. And this project is smaller scale. It's not a price bid. It's using public lands and to request giving back to the community. And this citizen power plant started out with the foundation holding the half of the rights to the panels, and the other half is open to the local residents of Beitou district and to Taipei City as well. So the power plant is shared, or the stake is shared by citizens. Then the current national policy is to have every school having PV panels. But you will see many PV panels in schools are located on the ground rather than on rooftops. And many teachers say that they can't have the students have access to the panels in the schools. So even though the panels are installed in the schools, but the students cannot learn that much about these panels because many private companies, many vendors of these panels would block the panels away without the students would have no access to them. So they cannot understand them. So many teachers would, when we started out the citizen power plant, we listened to the local students and teachers' opinion, and they said that, oh, they want to have the panels elevated from the rooftop so that the teachers can bring the students to visit the farm and to look at the panels. And the ceilings are quite low so that the students, in this case, junior high school students, they can reach the panels so they can feel the temperature. And they can really observe and the myths of the PV panels, because there are myths talking about how the PV panels may be reflective. It's too bright, and if you visit them and you see them physically in real time in place, you see that all these myths are busted. And why are we promoting citizen power plants? Because there are multiple important values, especially education. It's really important for us at the educational scene to incorporate PV panels into the education of students. And there is another example of being incorporated in energy education. In other countries, for example, in France, in Germany, citizen power plants can leave 3 times to 8 times higher of the profits to the local communities compared to private power plants. So citizen power plants have these social value other than just commercial value. And from this presentation, we talk about Taiwan's micro hydraulic power. It's not just small level, and that is 20,000 megawatts. And so what I want to talk about is micro hydraulic power plants that is really of a small scale that only has limited impact on the environment, and that's attached to the existing agricultural lands. According to stats in Taiwan, the potential for smaller scale hydraulic power plants, there is huge potential there. And another example would be in Japan. There's a town in Japan that has only 250 in population, and starting in 2003, there are renewable energy policies in place in Japan requiring this town as a pilot town for pilot project of power generation. And even until now, this village this plant can generate twice the energy required or used in this village. So they can sell the excessive electricity to the power grid, and the revenue will be used to revitalize the local agriculture. Nowadays, we feel like PV is in conflict with agricultural development in Taiwan. But from the examples of Japan and Europe, we see that renewable energy plans and projects can contribute to local agriculture. And it's local-based solution that can respond to local needs and even revitalize local communities. Taking this example in Japan, the benefits of selling electricity is used to restore the abandoned farmlands and to attract young people moving in, new farmers moving in. From the picture here, this farmer was an electronic engineer. They moved to this village and switched career to agriculture. And going back to the example of Taiwan, this is an example from Xiangtianzun. This community applied for incentives of citizen power plants by Taipower and by the Energy Bureau. So the empty frames in the picture here was a hydraulic generator by Taipower. In the past, there are manual power generators as well. And Taipower found it not profitable, so there are only empty frames left. And the local community residents felt that, well, the infrastructure is already in place, so they want to install a smaller generator here. And because the community members do not prioritize profits, they want to incorporate the generator and the charging pole next to this waterway, so that when tourists visit, when they need to charge their EVs, they can travel in the community, in the village, and the local residents can sell farm products or agricultural products to the tourists. So the community doesn't prioritize capacity or profits. They would look at it more comprehensively. Even though the community applied for the first phase of subsidies, but it's really hard to go forward. Why is it difficult? Because the community couldn't acquire the rights to the water there, and the water there still belonged to Taipower, so it's really difficult for the project to continue. And also here is another example. In Chuanlong Channel Waterway, the community, under the consultation of Water Preservation Agency, they even find endorsements by private sectors. They want to develop micro hydraulic power plants of 20 kilowatts. But the agricultural and water agencies still let the tender to be an open bid. And even though there is public participation, but that's less than 5%, it's way under the recommendation of the EU 60% or the Energy Administration's recommendation of 55%. So the community received subsidies from the Energy Bureau, but they cannot conduct a citizen power plant using the local waterway. I find the Taiwan's government's mindset requiring changing, because in Europe there are nearly 9,000 citizen power plants. 45% of renewable energy are shared or held by citizens. And the Netherlands, for example, is more progressive, stipulating that by 2030, 50% of renewable energy should be citizen power plants. And the regulations say that if the contracts are discriminative to public participation, then the contracts will deem ineffective. So there is a community that we visited. This community has solar PVs, and when the price is attractive, the local community can sell excessive power to have benefits and store it otherwise. And during our visit, we asked them, why are you so supportive of citizen power plant? And the answer we got was straightforward. They said that we need to support people's will so that they will support us in voting in the elections going forward. But that's pretty much the case in Taiwan. Here's another example in Japan, Kyoto. For the rooftops owned by the city belong to the citizens. They don't, when the citizens of Kyoto bid for these rooftops and to conduct citizen power plants on the rooftops, they don't need to pay back to the city government. They only need to contribute to energy education or environment education. Own experience in Taiwan, the failures resulted from neglect of local needs, the agricultural needs or the fisheries needs. If we look at examples in France and Germany, the design comes from the caters to local farmlands or to local fisheries. So the PV farms are actually adaptive to, for example, the French grapevines are protected by PV panels, and in Germany's case, the panels can help with the produce products, and in Japan there are facilities free offered to local residents to use. And here is another example of Belgium. EcoPower is one of the largest citizen power plants. It started out having a citizen participation as an item or as an item of the tender in the bid, and that's why it was successful. So we shouldn't follow the best value for money model. We should have other ways of opening up tenders. And current design of citizen power plants are adopting innovative approaches as well. And lastly, I want to talk about the price of purchase. In Japan, the price to purchase micro or medium hydraulic power plants are set in a very detailed manner. But in Taiwan, the price is quite flat, so it doesn't provide enough incentives for communities to build power plants. But another problem is that many communities want to have citizen power plants, but they don't have access to information. So they really need to find the information themselves. And that wraps up my presentation. Thank you. Thank you, Ms. Wu. Next, we will invite the second presenter, Ms. Chen Yuping, Secretary General of Taiwan Environmental Planning Association.
谢谢。好，各位午安。
Good afternoon, everyone. Very happy to have this opportunity to share with you all. Even though our association have participated in PV energy for 4 years, but we haven't talked about why is it the distance between PV and the community has been so far away. I think Xinping briefly touched upon this topic, but I want to focus more on this issue. When we want to develop in the solar panels, why is it there is always a conflict with the community? Is it because it's something that uniquely Taiwan, or is it something universal? Our association have always wanted to actually build something that can actually allow the panel electric energy and the to coexist with the community. So let's do a little bit of role play, and let me give you some stories. This is a very well trending topic. I think you would notice this news if you follow green energy. It is an anonymous foreign company who have worked in Taiwan for 6 years. Before leaving Taiwan, he talked about this story, which mentioned that their projects have always been blocked within the government agencies, and if they go to the local communities trying to develop, some people may ask bribery from them or threaten to threaten them or coerce them, or this sort of different scenarios that is was hard for them to understood. So that's why they say that why is the green energy become this bad thing in Taiwan. So that's from a developer perspective. I try to get to know the inside story. It's not an individual case, even though it's an anonymous report, but I think this scenario is actually true in Taiwan. Let's change to a different hat. Let's wear a different hat and think about what happened when green energy happens. This year, a lot of things happened. Actually, a lot of things happen every year, but this year, this is an iconic case. This is a Wayao village. In a small village, suddenly in front of the big temple, they want to build this solar power plant. Then they suddenly realized that why is it they want to have these huge PV panels in front of them without letting them know. So they started to protest and also had all these different situations. Also, Fangyuan recently, suddenly they realized that why is it we start to have developers coming in, discussing with others how to take over their farmlands for photovoltaic energy generations, but it's a state-owned land, so they need to have a local community communication, so it was not dealt with very well. People still complain quite a lot. Why would all these things happen? Who's at the wrong? Who's at the right? Is it because they're picking the wrong location? Why is it seems that for every location we pick in Taiwan, there are always conflicts? So coming back to Taiwan as a perspective, we do have our difficulty. For instance, this is the information 2 years ago, but it still applies to this day. 2 years ago, we have around 10 gigawatt. Now it's a bit bigger. We ranked 16th. Number one is not listed here because it's China. China is like twice or 3 times of the US, but you can see the trend. Every country in front of Taiwan are much larger in size than Taiwan. Also, in Taiwan, I've also looked at all these installed capacity, but in Taiwan, even though our installed capacity is only 10 gigawatt, but if you look at our land area, which is 36,000 square kilometers, ours is actually smaller than that of Japan. So it seems that our terrain only accounts for like 9.5 thousand square kilometers. Since these PV photovoltaic energy installations need to be installed in a terrain, then you will see that the density is much higher than others. With 10 gigawatt, you have this high density, and of course, these local communities would do feel these rapid developments and not able to respond to them. And during these developments, the government would also have it hard because they want to continue to promote this, but that's why we continue to face these obstacles. So that's the results. With 10 gigawatt, we already see this very high density. Qigu has like 1/5 of the land area and under the development area of solar energy. If you continue to follow the plan, 1/3 of the land area will be used as a solar power land. And in Pingdong, some of the lands they want to develop it other ways. For instance, in Jiadong, these land would be changed into a photovoltaic energy development. Then people will wonder whether or not that's reasonable, because how do we need to intervene so that we can discuss about this in a more reasonable manner? I think we do have this opportunity, and there are opportunities in other countries. How do we improve our current mechanism? So let's look at better mechanisms then. This is not a special case. We would first look at the cases in Japan and the UK. In some other countries, normally this would be the process that it will follow regarding PV sites. So if a bigger development project is to be constructed, before application, we need to have a prior consultation. You also need to have a public announcement. You don't at this stage, you don't need to receive a consent yet, but you need to make it public first. For instance, whatever the scale of the size, Japan requires all these to be made public. So if you want to have development, first you need to have consult with the government and also make public to the local communities. So local communities have an opportunity to know what would happen in advance. That also applies to the UK. In the initial stage, I separate the role of local communities and the central government. Before development, it also has the obligation to also consult with the government, and before that, you also need to be encouraged and then start to initiate these consultations with the local communities. So that's the initial phase. With this initial phase for these countries with a more comprehensive framework, this is something important. With the first step right, you will have the rest of the steps smoother. So with this initial consultation, you will have this impact assessment and have some basic understanding, knowing that whether or not the next steps will be smoother. And then for the application is really submitted during the permit and area, we will identify some potential issues, clarify these issues. During this process, your projects, before detailed design, you will need to communicate with the local community. The Japan also requested this way. You have to look at these case by case and see, and you also need to explain a more detailed plan to the local community and listen to the feedback and revise your plan accordingly. I think framework in other countries will also be similar. After you receive the construction permit, you will once again need to confirm and check with the local community. So normally you will have an initial review process to the final permit. So you will have at least 3 stages. So any of these process, if there are strong objections from the local community, the government would then be able to play the role as a negotiator, mediator. So this is what happens in Europe, in the US, and in Japan. What about Taiwan? Well, this is the most important one in my deck. A lot of things that we can improve upon. So let's discuss what's the approach of Taiwan. So this is the existing operational process in Taiwan. I'm sorry about the font, but it is small. But basically, it tells the developers what documents they need to submit and what relevant government agencies would do. The most important thing is over here. When you will submit it, you need to submit 6 documents. Let me enlarge it over here and see what 6 documents you need to submit. Before application, what they need to do is to prepare these documents are prepared. But of course, if they need to do the other projects, for these individual projects, they need to do more. But for PV sites, normally you need to prepare these 6 documents. This includes land consent form, also relevant local competent authorities and their consent letter, which includes competent authorities, local governments, etc. So this is something they need to prepare before you send for application. Now this is for preparation. Then coming back to the procedure in passing a application or PV site. First, you will need to consolidate the land, and then you send it for a submission, which is the one on the left-hand side. And then during this process, you also need to do maybe control of the land use, maybe change the land use, or to allow the land use. Or if there is a change of the river, then of course you need to have some stream control. Now if it's Taiwan, I think we are all familiar with it. But what I want to talk about is on the step, what happened before organizing a local briefing. Because the story we share with us, one of which is Fang Yuan. They have a local briefing session, but it seems that there's malfunction with the local briefing session. This is actually what happened before that. Let me compare it with other countries' approaches. That is before the application and during the permit. Before the application, according to our regulations, the most important thing is to get the consent letter from the landowner and of course the competent authority. If they want it to be approved, they would unofficially visit a competent authority. So these two are the most important thing for the developers. So I would say that this system lacks maybe like authority integration or consolidation mechanism, because you need to get the consent from different competent authorities, and this may take a long time. Some government agencies may take longer time. They may take into consideration a lot of different factors, and this means that during this process you have to go through this step by step. You also get to get the consent from the landowners. Now this information may be leaked, and that may attract maybe gangsters in the local communities to threaten you because they know about this information, and there may be some bad developers that will also intervene. And since you are a new developer, the government may feel that you are suspicious and may stalk you for a little bit. So during this process, the developers will try as much as possible to prevent this information from leaking. Then this means that initially, of course, before applications, no developers will want to leak this information and let the local communities know about this. And we know that in other countries, they have other approaches. For instance, the prior consultation should be put into the procedures so that it's not unofficial. You can just maybe talk about this, but or talk about this and has no consequences. The local communities, in that sense, have the obligation to lead the development of the projects. Also, when the planning agency wants to receive the review, then they would also let other relevant agencies know about this. That's not done in Taiwan, because within these 6 documents, there's no such consolidation. For the second stage, that is during applying for the permit, what you need to do, of course, is to pass the permits of land use with and also you need to also convene a briefing session. Now, the government didn't participate in this process, and this is different from the other countries. Without participation, bad developers may want to compete, or the local gangsters may want to blackmail, or you may be hiding some key information and feeling that things are information, but there are rumors already running around. People's concerns would not be addressed during the briefing session. And since no competent authorities is not there to negotiate or mitigate, it's hard for us to have a very good session or a very effective briefing session. So there are ways that we can refer to, and there are things that we can improve upon. So bad competition may involve maybe getting a land nearby, or buying land nearby, or buying it at a higher price, so to prevent you from coming here, or gangsters just want to blackmail you from you, or to say that threaten that what they would do, so that you feel that it's uneasy. The reason we have this process is because the government is not decisive enough to have a clear procedures, or the government is not there during this process. So there is this big, huge, vague area, which would then invite speculators to come in to prevent developers to do the right thing. And since the government is following a very vague review, this means that individuals would have a large and huge discretion. So passing the case is not good for them, but if anything happened to them, they may be accountable. So that's why some of the officers also do not want to be accountable.
案例第一个是
So here are two examples. One example is in Budai. It's a piece of public land. So the government took the initiative, and because the project encounters several issues with a bird species of a bird's habitat, but because the government took a role, so it was resolved. The second example is of a private line in Pingdong, and due to typhoon, the Pingdong government played a role of integration and to consolidate multiple pieces of private land and to negotiate with developers and to come up with a successful result of having around 50 hectares of PV farm, and multiple parties can benefit and all agree with the project. And because the government took the initiative to coordinate and integrate, so the local gangsters cannot play a part in this, so there is no avoidance of public communication, and this successful case was due to or resulted from a long journey of negotiation among different parties. So successful plans should involve multiple parties, especially in examples of other countries, and there were multiple parties in discussion. However, in Taiwan, due to local customs and due to the current system, the developer is the main vendor here, and local residents are involved. They may have relationships with local vendors and lease owners, but the local subjects, local communities are not taking part in the entire process. So there are so much protests in the local communities. It's because there are so many challenges that we face in practice, in reality. So here's a brief conclusion on how to expand ground-mounted PVs. I think the most important thing may be that the three pillars of the society, the government, the community, and the private sector. I think the government should take the lead in addressing these issues. Thank you.
那谢谢
Thank you, Yu Ping. So we'll move on to the Q&A session. Let's invite the moderator, the presenters, and the panelists on stage. So I'll pass the mic to our moderator. Good afternoon, everyone. Thank you to our two presenters. Starting from the morning session up until now, we talked about adaptation plans to climate change and to talk about land use, and now we talk about tangible measures of net zero and green power generation. And PV is the most common in Taiwan in local agricultural lands or aquaculture fisheries. And this new format of citizen power plants, we all see that the practice in Taiwan, there are so many insufficiencies in terms of regulation. We don't have sufficient regulations compared to European countries or the US, and we don't have enough public or civic participation. We don't have enough government support in this front. So we look forward to the response from our governmental representatives to see the stance of the government. And we have two panelists, one representing the Ministry of Economic Affairs, Mr. Deputy Director General Li Junli of Bureau of Energy, and Head of Aquaculture Fisheries Division at Fishery Agency of Ministry of Agriculture, Mr. Chen Wensheng. These are our two panelists, so welcome on stage. Thank you. So our panelists can respond from the Energy Bureau's perspective and the Fishery Agency's perspective. How can government agencies respond to the expectations of our general public, of our people, how the government agencies can help our society and can help our citizens to participate in renewable energy and green energy development. And each of our panelists have 10 minutes to respond, and we can have more time for Q&A and discussion. Thank you. Hello, everyone. I'm honored to attend today's forum, hearing from our two presenters who are experts in this area and who have long been monitoring the development of green energy in Taiwan and who has offered us a lot of recommendations in the past. And to respond two things. The first on micro hydraulic power generator. I think the citizen power plants are smaller in capacity compared to the regular micro hydraulic power plants. The community power plants are smaller in scale. In 2019, we formulated incentive mechanism for citizen power plants, and that's implemented in the same year. And for citizen power plants have to be proposed or applied by citizens. And for CSOs, citizen groups, they need to be registered at the government. So when we first announced the incentives that are very generous, we first have $2 million in incentives. Once you initiate, you would have $2 million. And as you move forwards, we offer around 50% of investment in further incentives. However, most applications never proceed after preliminary planning. There are two reasons. First, in preliminary preparation, we provide $2 million. That's quite generous. So many CSOs were motivated by the 2 million. So these organizations are registered or formulated just to get the $2 million. So they would end the project as soon as they receive the $2 million, because the further development is quite complicated. So we review that. We don't see the incentive mechanism sufficient. We attracted those who are not devoted or committed to citizen power plants. So we amended the incentive mechanism in later years, that the citizen power plants had to be connected to specific communities. The community residents need to take the initiative. And we also reduced the incentive of the preliminary proposal down to $600,000, showing that you are not aiming at the lofty sum to apply. So after that, we received several cases. We approved 26 projects. According to current regulation, there are 3 projects that moved forward. Some projects found private companies and they collaborated with private companies going forward, so they didn't proceed with the citizen power plant projects. They find it, they find the procedures or the applications burdensome, so they just worked with private companies instead. Because receiving government subsidies, you need so many receipts and all these different procedures. So currently there are 3 projects that went forward. So even though the entire system is far from perfect, we still had tangible results. And in the process, we encountered several difficulties. For example, for the micro hydraulic power plants, it's not profitable. It doesn't have high profit. We know that Taiwan's electricity prices are cheap, so it's different from Europe because they have higher electricity prices, so it's quite profitable there. And in Taiwan, sometimes citizen power plants have higher electricity costs compared to the electricity provided by Taipower. And with subsidies, indeed, these smaller scale power plants can make a profit, but smaller profit. And one example is in a local village. At first, there are 30 plus collaborators, and after a while, there are only 4 people left, because all these citizen households wanted to be involved in the first place, and their family members, their children probably discussed the profit, and then they decided that it's not profitable enough, it's not lucrative enough. So many citizens were reluctant to participate in the future and going forward. And just as Ms. Chen mentioned, that in solar power projects, in PV projects, there are indeed protests and problems in the local community, and we do have all these gangsters in place and corruption in place. And we work with the Ministry of Justice, and the Ministry of Justice already investigated 30 individuals and indicted several. So it's really difficult for us to distinguish between local protesters and those with hidden agenda, and we need to put more effort into that. And our presenters put it well, that the European example is that the communication started way before approving citizen power plants. Our current regulation is that the public hearing or the public meeting or the negotiating meetings need to take place upon approval. So that would be later in date. And just as Ms. Chen mentioned, that according to local culture, because we have limited land, the competition is fierce and harsh, so most developers are reluctant to disclose information before they receive approval. They don't want to release such information because they feel that there may be competitors getting to know their information, getting to know what they're gonna do. So before the developers approve, they kept it low, and upon approval, after they receive approval from the government, only then they hold meetings and to communicate with the local communities. And here's the dilemma, that now the government is already approved, and the hiccups before the communication then only be seen, and that's a trouble here. So I think going forward we can try to address this, and because Taiwan has such a dense population, most population central around the plains in the communities, so the space used for the renewable energy plants is really close to our residential area. And just as the Wayao village example, that is a small scale PV farm, and the landowners would feel that why should we have the citizens' consent if it's on private lands? So here's this contradiction. And we are formulating now that we need to maintain a good relationship with the local communities, and there should be a certain distance between the projects and the local residential area, so that we want to balance between the rights of the landowners and the residents. So we are trying to come up with measures to balance the different parties' interests. My time is up. I think that's something we want to do, because for solar power, we actually progress quite quickly. We are now promoting for 13 gigawatts. Europe has been working on solar for so many years. We started in 2016. Our capacity was only 1.2 gigawatts, and now we have reached 13 gigawatts. So that's 13 times growth. So in comparison, Europe has worked on this for a long time, and we have put in a lot of efforts within a very short time. And people are less familiar with this, and there's doubts, mistrust, or distrust, or myths involving the radiation or pollution. And so there's so much doubt because people are not familiar with this issue. And as solar becomes more widespread with our more comprehensive systems and mechanisms, I am positive that this is a journey that we must take on, and we can all work on this together. Thank you. Thank you to Deputy DG Lee. Next, we will invite Mr. Chen, Head of Aquaculture Fisheries Division, to respond.
Moderator, presenters, panelists, and ladies and gentlemen, good afternoon. I am the Division Chief of Aquaculture Division from the Fishery Administration at the Ministry of Agriculture. Thank you for the presentations. I will first talk about I will talk about the current situation and regarding the coexistence between the fishery and the electricity, and especially regarding the later slides. I think I started knew that I entered into starting from 2020 when I faced into a fishery and electricity symbiosis. I actually faced many obstacles, be it relevant regulations or first-hand implementation. What shocked me actually was that I think it's in 2022, on November 1st of 2022, Qigu local community went to the Executive Yuan and protest. What I found is that, indeed, there was this information gap. This information gap was mentioned by the previous speakers. That is, the information disclosure is not transparent enough. So I will start sharing from this part. I think the previous speaker mentioned that in Qigu, 1/5 or 1/10 of the area was developed as a fishery and electricity symbiosis. But actually, it is on development. That was the plan. It is possible that in the future, the development projects would not be passed. But then what would be seen from the society or from the general public is that, well, it's hard to divide them, right? It's hard to separate because they've already applied for it. So the general public will feel that the development project would definitely be passed, and of course local communities will be concerned. I really agree with what Secretary General Chen mentioned. The government has a role to make public and make transparent relevant development information, and I'm very grateful for the Energy Administration, be it in PV or in fishery and electricity symbiosis. On their website, they've make public, I think, the area of development currently. And I also noticed that, for instance, in Jiayi County government, in Tainan and in Kaohsiung, where the majority of the fishery and electricity symbiosis is, their local websites would also make sound the area of the development projects. I think the government, of course, is gradually improving and updating their information, be it pressured by the public or the academia. At least the government is gradually trying to comprehend the disclosure of information. That's the first thing. The second thing is from fishery and electricity. Well, agriculture would still be the foundation, whereas green energy is only something on top of it. So from the fishery administration's perspective, of course, what I would look at it is that green energy is a value add, so we support that because green energy indeed is something that the agricultural industry also needs to be involved. But the most important thing is that it shouldn't distract or deteriorate the original function of fishery, because we need to ensure the food security issues in Taiwan. They need to have stable sources of food. Since we are an island country, so food security plays a very important role to us. So under that premise, when we are developing and combining with green energy, the Ministry of Economic Affairs and the Ministry of Agriculture worked very hard to, first of all, build a legal framework, and secondly, to look at the environmental and society issues and reviews. So this involves environmental and societal issues. They would also involve the local communities for dialogue. I can't really say that we involved everyone, but I think at the government perspective, we work very hard to communicate and exchange our different opinions with local communities. And of course, we face different obstacles because some people would just object it and we would not be able to force them. But of course, during this process, there are indeed, or there has been indeed, I would say, conflicts or long communication. I think all these are just process. And indeed, from a developer perspective, the developers will feel that why is it that the government is not very efficient, or the fishers will feel that why is it you are not on our side, you are not reviewing or helping us. So we are in a difficult situations from both parties. We have pressures from both parties, but what I want to clarify is that local governments as a frontliners, they are the ones reviewing this information, and local governments also are under a lot of pressure because they are the ones that need to face the developers and the local residents front line. So I do agree with what Secretary General Yu Ping mentioned. We need to include the local community, and also we need to include stakeholders in this overall process. Take Qigu PV site protest case. After the case, the Ministry of Economic Affairs and the Ministry of Agriculture in the large PV development sites establish local task force stations. So if local governments is not able to act as a negotiator, then the central governments can intervene and help with this. I'm not saying that we can cover all these conflicts, but at least we try to be more reactive, more proactive in this manner, and support local governments if they need us. So that's the second part. Next, I want to talk about in the development of PV sites. In addition to what I just mentioned, the workstations that we've already established to help solving problems, the Ministry of Agriculture and the Ministry of Economic Affairs is also gradually trying to link and include local agricultural farmers. We want to involve local stakeholders. In Tainan and in Kaohsiung, we are including local agricultural associations which can sign a MOU or a letter of intent with the developers. Of course, ultimately, individual development cases will still depend on individual farmers to be involved, but at least the association can act as play a role in this. But and to ensure that farmers are involved in this process, and the ultimate site would still allow the farmers to have the space and the size that they needed. And since these sites, after the contract would take 20 years, if during this process the original farmers decide not to continue or want to exit, or want to stop as a fishery, local fishing associations can intervene and say that I have different farmers to maybe match or pair up new farmers to take over the these existing sites. So these are the three things that I want to talk about. Thank you very much, Division Chief Chen. I personally also have some thoughts that I want to share with you. 20 years ago, when I was studying in Germany, my doctoral dissertation was on investment and development. And I learned what environmental impact assessment means, what public participation means, what are the factors that needs to be involved in developments. And then afterwards, I came back to Taiwan and I knew about the Phase 3 developments of Taichung Science Park. And I look at some of the factors that was neglected in public participation, because public participation is not just about the interest of the landowners, but also local residents, people's interest, or the who may be impacted. Now, starting from the Taichung Science Park Phase 3 to the development cases that we know so far in EU, under the framework of the Aarhus Principle, Germany regulates that public participation needs to be as early as possible. For instance, as the information received during the design phase, during the planning phase, it is already public participation is already requested, and this public participation is not about the developers organizing a public hearing. The government agencies need to play a negotiation role, playing the role of a negotiator and a coordinator. And I think that's the mechanism of Germany, but for the past 20 years, little has been changed in Taiwan. Starting from the third phase of the Taichung Science Park to this day, now we have smaller scale developments. Things are still the same, the mechanism is still the same. The mind state may have slightly changed, it become more flexible, but it's because of green energy. What about other development? I'm not sure. So what we find is that maybe in Taiwan, culturally and systematically, or legally speaking, there may be a lot of adjustment that we can do, and that's why the Aarhus Principle can actually give us a lot of inspirations. Now that with the new models coming in, such as the citizen power plant, it actually involves the consensus and the awareness of the local communities. And even though in Taiwan, we would not, because of the dense lands that we have, I know that Professor Schumerus actually talked about that, how he himself participated in a power generation co-op. He actually owns a part of the shares, and we want to know how the co-op linked with local communities. And so it's not just about how much money you have invested in it. It is the voices of every resident, and it is how these local communities shape local culture. So this is a newer awareness, but this is quite challenged here in Taiwan, and there is still a huge room for improvement. So this is just a quick summary. As a scholar involved in researching in investment and development for 20 years, as an NGO that continues to work along with the NGOs, this is what I observed regarding the legal framework of Taiwan and regarding the government culture of Taiwan. I think be it the public or private sector, there are still a lot to learn. So that's some of my thinking. I think we still have some time now, and I'd like to open the floor for our audience and see if any of our audience have any questions, especially regarding our moderator and our panelists.
发言之前，告诉我们您的大名。
Before you speak, please tell us your name and your organization. Hello, everyone. I am from Donghai University. I'm Yan Chongfen from Ecology and Research Center. So I participate in the forum since this morning. And first, I must acknowledge that for this event following Human Rights Toward Net Zero, I think it's such a valuable task that we can hear, we can listen to multiple voices, different voices. And just as what Professor Fu, you said that 20 years ago we were protesting against the industrial park in Taichung, and now we don't see a lot of progress, but I feel like the event today is a proof of growth, a proof of progress. And I want to congratulate the organizers. Secondly, in your dialogue, with our two panelists of the session, we are talking about citizen power plant. We are talking about what the Homemakers Protection Foundation mentioned, that we need to have this proof of freedom that everyone can have. Everyone can have green, renewable energy. Everyone can have access to electricity. And the government agencies, if the government agency can advocate that, we can reduce some hindrance to have more people involved. And so my question is that from the government's perspective, Mr. Li, you mentioned that there are so many challenges in a journey. So which measures do you think are possible for the government to help us as participants, as citizens, to participate in the process? So that's the first question. The second question is that communication matters. The first thing is that we need to be willing to speak or to speak up, because I work with junior high school and elementary school students, helping them to be more interested in the environment or to understand environmental ethics. And I find it a huge challenge because the teachers are not comfortable speaking up. So how can they teach the children, the students, to speak up of their opinions? Because we know that the Western world, they always teach their children to speak up, to voice their opinions. So it's such a challenge in our society. It requires a lot of effort from the scholars and from educators. And I see so many faces here today. I may be wrong, but I feel that sustainability development, I think education needs to play a very important role in sustainable development. I feel that for the smaller scale citizen power plants, the priority is not the commercial value. The priority is education of the community. We need to take priority in outreach or to sow the seeds of education in the local communities. We often talk about sustainable development, especially sustainability. I think education, I think citizen power plant is a very important thing in the education. I think that is something that we need to recognize and acknowledge. So here's my 2 cents from our two very important government representatives. My question for both of you is that how can you help us to achieve these goals that I just mentioned? Thank you. Thank you for your question. We will collect one more. I will speak. I have 2 questions. The first question is that when we look at other countries, France, Germany, they have all these successes, and why we are not as successful? Why is it that the foreign developers are afraid to invest in Taiwan now? And what's the problem with the government? Is it because of the BOTs in Taiwan? Are they the hindrance of these developers? Second question is that we see so many typhoons now, and for these solar panels or the wind power farms, would they be affected by the natural disasters such as typhoons and earthquakes? Are they not suitable for Taiwan because of the natural environment or natural disasters? Thank you.
好，黄先生，谢谢您的提问哦。
Thank you, Mr. Huang, for your question. Okay, so all of these questions are addressing the government. So to democratize electricity, what are the roles or how the government's roles can be changed? And how can the government do more in environmental education? And the other questions are for the unique situation in Taiwan's climate, weather, and geography, and all these renewable power generation facilities be affected by natural disasters. So I'll pass the mic to our government representatives. Thank you. I must respond to the audience member from Donghai University. You just said what I wanted to say. I think citizen power plants in Taiwan, the failures or the not so ideal successes, that is tied so closely with our education, with our culture, because in the past, under authoritarianship, it's very difficult for people or for students to learn how to express ourselves. So often when we try to promote citizen power plants, people were always thinking about how much money we need to invest in, what kind of return can we get. And once we increase the incentives, the financial incentives, then it would hinder the citizen power plants because it's profitable. But people still look at profits when they think about citizen participation. And now we do have more and more people paying attention to public affairs. But as we promote community affairs to find enough people within one single community that pay attention to these topics, it's very difficult. Indeed, we have a lot of people who care about these issues, but they scatter across multiple communities. It's not easy to find enough people focusing on the same topics within one community. So it's really difficult to conduct these projects that are community-based. I started participating in the Citizen Power Plant project since in 2018, 2019. We now require the community citizens, at least 15 community residents, to participate in a citizen power plant project. You can't have external individuals and parties involved. That's not a citizen project. So for the citizens participating in the power plants, we require the community to contribute to 20% of the investment within a single citizen power plant project. We do not dare to set the bar too high, because it's very difficult to require a lot of people to invest in such higher money. In the past, we had professional citizen power plants. There are a group of professionals finding local community residents, one or two, and to venture into the so-called citizen power plants. So they are not citizen power plants, so to speak, because they are that is a profession. So, and then we changed that. We discouraged the people. And so it was a part of the process. It's a learning process, because we tell those saying that indeed these are all individual projects, but there is specific or singular profit-seeking organization involved in 9 different citizen power plant projects. So we try to persuade the communities to not to venture into the projects this way. And in comparison, public participation and democracy has a longer history or historical context in Europe, so the people there may be more familiar with participating in these public projects. But still, from the government's perspective, we want to encourage more and more citizen participation, and we do see more and more successful cases now. And I also want to address the successful cases initiated by the government, including Budai's case and Pingdong County's example. These successes need to be more widespread. We see 5,000 programs or proposals a year. The Ministry of Economic Affairs don't have the capacity to take lead in all of these, so we want to duplicate successful experience in the past. And in Taiwan, people may wonder that natural disasters like typhoons and earthquakes may impact the PV or solar and wind farms. From practical experience, statistics show that recent typhoons, especially in central and southern Taiwan, that are damaged with more severe damages. We don't know about the details of the minimal damages that can be repaired on their own, but we see only 6 cases in Kaohsiung and 1 in another county, so that's quite rare among the 5,000, because all these wind farms or solar farms, they need to be the technicians need to certify the programs. And indeed, we do need to work harder, especially the government, and we want to learn from the civic society, because the government is not as familiar with civic movements, citizen movements, and civic participation. So we need to continue to learn. I will address the questions from our 2 audience members. And because Mr. Li has said, Mr. Chen has answered more about that, so I will talk more about the fisheries, aquaculture fisheries. Indeed, aquaculture requires a lot of electricity. So for the, we will not address the larger PV farms, but for smaller scales, I visited Taidong County and Jiayi County, and I see smaller scale of aquaculture fishery PV farms. And the local fishers purchase smaller scale PV panels on their own that can store solar power and power the equipment required by the fisheries. And it can use, it's a connected grid. So in the morning there is power storage, and in the afternoon, in the night they would use the power stored as well as the Thai power grids. And I feel like the Ministry of Agriculture is adding new regulations. We do want to encourage the local fishers to generate the power or electricity that they need to use. So that's adding to Ms. Yan, to generate power to use our own. So electricity is something we need. It's essential to our daily life, but rather something to make profit. It's a resource that's vital to our households. And apologies to our audience members, because of time constraints, we cannot open for more questions, but I know that we will have more opportunities in the future, because today is only the first time we officially talk about Aarhus Convention. We'll have other opportunities to talk about this in the future. But I feel like our 2 presenters may have something to respond, so we will have 1 minute for each presenter to respond. I want to respond to citizen power plants. I think it's a new thing. When something new emerges, we put a lot of effort to prevent corruption. And it's such an unfortunate thing, because many years ago, as we were advocating for citizen power plants, we learned from the example of Europe. There is an organization called Rescode. We asked them how we can deal with identity theft of citizen power plants. And then the answer was that as long as you ensure there's no profit, and you can there is no way there is corruption in place if there's no profit to make. And now, and a lot of programs are not for profit or corrupted. They just really need the rights or the local government's assistance. I feel that local citizen power plants shouldn't just be a mandate of the energy agencies. It should they serve multiple purposes in the local community. When we only look at output capacity, when we only look at the utilization, it's really dangerous. I often hear from government officials that the public servants saying that the citizen power plants are good in intentions, but we are trying to benefit individual communities, and I find it weird. Why is it something that we need to avoid, to have the communities being benefited from the projects? The EU has regulations requiring energy transition to put people in as a priority. And in the past, last year, as we amend renewable energy regulations, we wanted to put in protection for citizen power plants, but it was not successful. I want to discuss the regulations in the future, allowing the public servants to negotiate so that there will be no hindrance for the communities going forward.
Very happy to be able to present and share the forum. I think the government representative also shared the same thoughts. I'm very thankful. I think this shows that to some extent we share the same experience and same feelings, but how can we turn these feelings to practice? Maybe not just to quickly amend the laws and regulations. Maybe within the existing mechanisms we can still already have some try something new. For instance, maybe for prior consultation we can make it into an official procedure, so that I know that the governments may have some concerns and worries. And Vice Director General Lee also mentioned that you don't know much about these citizens. Indeed, individual citizens, when they face the government representatives, they may have different aspects and have different expectations. But I think that means that don't guess, don't speculate, just get involved and interact. Don't look at it as a defense mechanism. I think what it needs to look at it is to have a system in place. When the developer is knocking on your door, presenting to you that they have this idea like that, what we need to do is to try to look at it from your own professional background and think whether or not there is a reasonable basis of that development, be it from a societal, an ecological, and economical perspective. Maybe that's not enough. You need to go to the site and actually look at this. Look at the situation. Maybe it doesn't need to go deep and all at once, but then at least go to the local community and look at the concerns of the communities and see whether those concerns are reasonable. I think we're all comrades, I would say. We're all Taiwanese people. Sometimes you look at your roles too distinctively, and sometimes at the briefing sessions, people are just there to fight, but it shouldn't be that way. Because if everything only happened by then, if government representatives is there, then things would get scary and it would not be able to continue. I think if we all have good intentions, if we maybe, for instance, we continue to increase the amount of PV and also amount of fishery and electricities, we may be impacted. But if that's the case, then we do need more communication. We may need to change the mechanism. In terms of CEOs, we do want to be active and see if we can assist the government representative in any sense. I think for the overall societies, it's also the same way. This is the responsibility of everyone. We need to move forward and to start have a real conversation. Thank you. Yes, when we talk about the development of green energy, it is not only a legal issue, it is also a democracy issue and a local democracy issue. Professor Schumerus, when he was giving a speech in Zhengzhi University on Aarhus Convention, he says that the convention is actually, this convention, the value of the convention is an environmental democracy. So this is not just a convention, this is a democracy, and this democracy involves all stakeholders, and this is something that we all learn from. Environmental education is very important. We need to know more about our environment and our rights. And the awareness we have for our communities, so that we can further environmental democracy. This sum up of our session. I think officially the next session we will have a break time at before the next session. Then we will invite Professor Schumerus to come to the stage and share with us his observations and feedback. So thank you to our panelists and our presenters, and thank you everyone. We'll take a short break. Okay, thank you for your participation. We will take a short break until 4:30. We prepared some snacks for you. Also, please, because we are using recyclable utensils, so please return the plates before 4:30.
是人与生俱来的基本权利。当你想要玩乐，就要开。
Next, we will come to the last event, that is the panel discussion and the Q&A session. We will first like to ask the chairperson of Environmental Rights Foundation as the moderator. Thank you for sticking with us till the last session. We're still about 30 minutes. With these 30 minutes, we will first ask Professor Schomerus to first he had prepared a slide to share with you not so long. Afterwards, he will briefly respond to his observations after this long day of events. Afterwards, we will have about 10 minutes for Q&A, but we have a very tight schedule. I'm very sorry because of the venue restrictions, we have to end on time. So just to let you know in advance, and thank you for your patience. Next, we will first ask Professor Schomerus to share with us his presentation.
Yeah, thank you very much. I now have a quite challenging task to keep your attention for the last minutes of this long day. And I just want to continue with very few slides of my presentation from this morning, and then I would give some comments on the sessions we had. And the first is about you might remember I wanted to tell you about what can you do with the Aarhus Convention, and with the first pillar, a right of access to environmental information. And this is just an example what you could do with it, especially if you work with NGOs. A campaign, a political campaign. And this was a campaign which took place many years ago. It was about agricultural subsidies, because in the European Union, agriculture has a big budget, and there are billions and billions of euros distributed to farmers. And it was secret who got this money, but it is taxpayers' money. And so people wanted to know who benefits from these subsidies. And so they filed applications for information, for environmental information, and this was successful. And you see here, this is now King Charles, and he was one of the big benefactors. He got a lot of money from these subsidies, and so this became public. And then the European Union changed its laws, and now this is transparent. It's open to the public. So this you can do with this right of access to environmental information. Start a political campaign. And I also want to briefly address the second pillar of the Aarhus Convention. And I heard it this morning, and I also heard it before, that there's a problem here with public participation. And the one question was, is public participation only necessary when there is an EIA, an environmental impact assessment, or is it also, or can it also be necessary if there's no EIA? That's what I understand, for instance, and so the answer of the Aarhus Convention is yes, it can also be necessary if there's no EIA, if there's a significant effect and significant impact on the environment. So an EIA, an environmental impact assessment, is not mandatory for public participation. I heard this might be a problem here in Taiwan. And And another point is Article 8 of the Aarhus Convention. It's also about public participation during the preparation of executive regulations and generally applicable, legally binding normative instruments. And the big question here is, does it also include parliamentary laws, statutes? And so this is still a question. We had a case, oh sorry, no, this was, oh, sorry, yeah. We had a case concerning Slovakia, where my compliance committee said, yes, also parliamentary acts must, before they are sent to the parliament by normally the government, undergo public participation. So before it goes to the parliament, the public must have the opportunity to participate. And there's a new case now regarding UK, Great Britain, and you know that Great Britain left the European Union, a very sad story. And the question here again is the Brexit regulations, which took over most of the European environmental law, was it mandatory to participate the public before it went into the British Parliament? The British government says no, because in the Parliament everything is discussed, and this replaces public participation. The communicant here, which is Friends of the Earth, says we need public participation beforehand. This is still a pending case, so I can't tell you about the result, not yet. But this has an effect, of course, on legislation in every of the parties of the Aarhus Convention, also in Germany, because this is not normal that every law with an impact on the environment has to be publicly discussed before the parliament. And yeah, I think these cases are quite interesting. Yeah, another point is the third pillar, which is access to justice. And the third pillar regarding the environmental information access, this is quite unproblematic here, I would say. But I heard also that there are some problems with this in Taiwan. And one very important point here is that every NGO, every environmental NGO has a privileged position. I think I mentioned this briefly this morning. So it must be guaranteed under the Aarhus Convention that NGOs have access to courts and can file lawsuits against decisions of the administration which affect the environment. And I don't know whether this is implemented in Taiwan, but might be interesting. And there's also an article 9 paragraph 3 which opens up access to courts beyond the issues mentioned in Article 6. And this is quite problematic because it says here, each party shall ensure that where they meet the criteria, if any, laid down in its national law. So national law can define the criteria. But my compliance committee said this does not mean that under national law, access to courts can just be forbidden. No. Access to courts must, in principle, be open to the public. And so this is just very briefly. I will, due to our limited time, be very short here, and just look at, I think we had this. There are various cases. I won't bore you with all these cases here. I think we had most of them. One case, last case, I would like to mention here. It's a German case. It's about the environmental NGO WWF, so World Wildlife Fund, and Greenpeace. And according to the German law, these NGOs had no standing, had no right of access to courts, because they had no internal democratic organization. So these NGOs are operated like big corporations with a CEO, but they are not democratic. And our law says, but there must be elections to elect the CEOs and so on. And so they went to my, filed a communication at my committee, and we said the German law contravenes the Aarhus Convention. So the German law must be amended now, which is happening at the moment. So we had these conclusions already. This is was very briefly some remarks, and my question is, or how far have you really implemented the Aarhus Convention in Taiwan? I mean, you are not obliged to do so, because of course Taiwan is not a party to the convention, but I heard a lot this morning that there's a lot of initiative here to fully implement the Aarhus Convention, and I really appreciate that. And I will report to my committee when we have our next session in December about this conference here. I think they will really appreciate this conference. And just some final remarks, just in 5 minutes. So the first session was about climate information, transparency, net zero. I just wanted to mention that there is a problem, it's a general trend worldwide about the acceleration of procedures. So we have this in Germany. We have laws in Germany, especially because of the Russian aggression on Ukraine. Procedures must be speeded up a lot. But our Aarhus Convention says for public participation, we need sufficient time for the public to give their opinion. And so there is a trade-off here. So between the Aarhus Convention and the current development, the current situation. I think we haven't solved this problem yet. And then we had this session about urban, which I also found very interesting, about mitigation, about adaptation, and so on. For instance, in Germany, we have a special act on mitigation, which is the Climate Change Act, and we have another special act on adaptation. In German, the Klimaanpassungsgesetz. And so my question here would be, do you have a Climate Adaptation Act in Taiwan? And might be an idea to think about that. And I also liked the examples which were given, for instance, of the German planning system. And for instance, in Germany, already 100 years ago, we had this idea of the green garden city. And so many cities in Germany are planned like that. And then the next session was about, or the last one, that was about green energy. And yes, I will finish very soon. Yeah, thank you. It was about green energy. It was already mentioned that by Professor Fu that I'm also involved in this topic. I'm a co-operator of a wind farm. I started planning this wind farm and so on together with students. It's a student project, and we've been operating it since 2017, and we started a cooperative. And a cooperative is a very democratic way of participation, of financial participation, because in a cooperative, everyone has one vote, no matter how much money you invested. So we have relatively rich people who invested 100,000 euros. We have, let's say, normal people, not so rich people, they only invested 500 euros. But they all have one vote, and we all are committed to renewable energies and to financial participation of citizens. And this idea, so when you financially have a benefit from a wind farm, then you like it. And it may be in your neighborhood, and you're not disturbed by it. You like it, because it has a positive effect on your bank account. That's perfect. So it's the best way to enhance acceptance. And so what I would also like to say is here that, what is very important regarding green energy, that it must financially be profitable. And so you need a feed-in tariff system or something like that. And I looked at Taiwanese electricity prices, which are, compared to Germany, extremely low. In Germany, we had, when the war started, the electricity price went up to 40 cents per kilowatt hour. 40 cents, euro cent. And it's now down again to like 30 euro cent. Taiwan, less than 10. That's what I read. Wow. So if electricity is so cheap, it's really challenging to make renewable energy installations profitable. To be honest, higher electricity prices are good for the environment. Because then you invest more in renewables. On the long run, renewables are the cheapest way to produce electricity. And but on the short run, you need money for investment, but it will pay. It will pay. And in Germany, we have a system that there's a fixed feed-in tariff, which is then made by tender bidding procedure, but then you have a guarantee for 20 years. So in my wind farm, my wind turbine, we get like 9 cents per kilowatt hour. So, and it's guaranteed for 20 years, and this is profitable. So I think I just stop here. Now it's 10:02. I think that's what we agreed upon. And yeah, I would just like to thank you very much. I'm really grateful to have had the opportunity to take part in this wonderful conference. And I think these kind of conferences are really necessary to push environmental democracy. Thank you very much. Yeah.
Thank you to Professor Schumerus to be right on time. Thank you for being right on time. So we now have 10 minutes left, opening to the floor for our audience members to ask questions. And I'm sure you all have a lot of ideas and questions. Do we have any? Yes, please go right ahead. My question for you is that For Aarhus Convention, the 3 pillars, the 3 spirits, because Aarhus Convention doesn't talk about how when local residents, whether they have the right to veto or approve for a certain project. And also Aarhus Convention doesn't mention whether the developer, whether it's private company or the government, and the local community members can have a contract or a contract negotiation in the process. Because in Taiwan, there are fragmented regulations talking about contract negotiation between local communities and developers. For example, for radioactive waste disposal in Taiwan, requesting local governments to set up a vote to install something, and I feel like that is the right to approve or veto. And for environmental assessment regulations in Taiwan also stipulates that if the environmental impact assessment doesn't pass, the development will be vetoed. And that is, in a way, grants the local communities the right to veto a project according to this law. And for contract negotiation between local communities and developers, we do have similar cases in Taiwan. For example, the 3rd phase of Taichung Industrial Park, that is the result of a negotiation in a lawsuit. And in wind farms in Yunlin County, there is also contract negotiation between local communities and the government, but that's not a result of written regulations. So my question is that in Germany or in European countries, do you have any laws, regulations, or conventions granting right to veto or approval for local communities and the right to negotiate contracts, and how the framework is constructed in Europe? Do we have any other questions from the floor? We will collect one more if there are more. You have no questions? No further? Okay.
For this interesting question. Yes and no is the answer, because in Germany, the municipalities, the villages, the communities, they have the right to govern their own issues by themselves. So they are independent, quite independent from the state. So against the will, against the veto of a municipality, a wind farm cannot be built, for instance. So this is similar. However, we have a law in Germany, which is in the Renewable Energy Sources Act, which now says that the municipality must be financially participated by the operator, for instance, of a wind farm or a ground-mounted solar farm. So the operator must offer the municipality a certain amount, a certain tariff of, let's say, ½ cent or so per kilowatt hour. So the municipalities benefit financially, like like neighbors who financially participate. And so the mayors and of the municipalities, they really they like this. And for instance, a former student of mine is the mayor of a village. And he said, well, I want this wind farm to be established because then per turbine, the municipality gets 30,000 euro per year. And if there are 10 turbines, it's 300,000 euro per year. For a small village, this is a lot of money. And so you could say this is kind of corruption, because then by paying, you will get the right to establish a wind farm. So against the will of the community, it's not possible. But there are other measures like planning law, state planning law, which say that there's this, what we call Raumordnung in German, so spatial planning, and the community and the municipality is bound to this planning. But they also have a say in this planning. So it's not just a top-down system, it's also a bottom-up system. So it's a bit more complex. That's why I said the answer is yes and no at the same time. So there's no simple veto right, no. But it's a bit more complex. Everything in Germany is more complex.
So everything in Germany is complicated because the legal system in Germany is really, really complicated. But Professor Schomerus mentioned a point that top-down versus bottom-up. Taiwan really prefers top-down. People expect the government to regulate or to mandate certain things to happen. And the entire democracy actually relies on bottom-up. We rely as the citizens and the communities to initiate things, but we need to cultivate that spirit because we are a relatively young democracy. There's so much we need to learn, so much we need to cultivate, especially environmental democracy. We're facing this issue in environmental democracy. We have 5 minutes left. Do we have any other questions or feedback from our audience members? Please be brief. We have one that hasn't spoken before, so we'll have this audio member to speak first.
Really nice to be here to listen all of participate, and which give me a lot of insightful ideas. And my question is that based your observations and anything, and how can Taiwan improve public participations to accelerate, yes, this kind of communication with public? How can we make our citizens know that we should focus on environmental democracies? And yes.
Well, I could talk hours on that, but yes, how to improve public participation to enhance environmental democracy. I think the first thing is you need a clear law on public participation, on the role model, on the basis, for instance, of the Aarhus Convention, the 3 pillars of the Aarhus Convention. So why not establish an Aarhus Act in in Taiwan, an Aarhus Act, which just is a bit of copy and paste of the Aarhus Convention. Although it's not mandatory for you, I know, because Taiwan is not a party of the United Nations. Okay, but that doesn't matter. But you, as a civilized and very progressive and very high standard civil society, I think you should be able to do this. So, an Aarhus Act, the Taiwanese Aarhus Act, TAA. This would be my answer. Yeah.
Yeah, I think Professor just proposed that maybe we can actually have a Taiwan Aarhus Act. I think actually in Taiwan we do have these a lot of convention implementation act. Because of the limitation of politics, we're not able to participate or ratify these international conventions. But with implementation acts of these international conventions, we're able to domesticate all these laws. So maybe the Aarhus Act is something that Professor Schomerus proposed, and that may be the future direction that we can work on. Aarhus Convention Implementation Act in Taiwan. Okay, any other questions? Oh yes, Mr. Huang, please. I have one question. we really admire Germany. A lot of the scholars also study abroad in Germany, and I heard that it seems that they care about public interest a lot. So I want to know that many legislators or councillors in Taiwan use public interest to maybe gain corruptions or gain money from it. Is it also happened in Germany, where they use these public matters as a way to threaten or get money or get bribery?
Question. But yeah, of course, also in Germany, bribery, corruption does exist. In every society it does exist, but there's a corruption index, a worldwide index of corruption. And I don't know where Germany actually is, but it's relatively far up. The best countries regarding this are the Scandinavian countries or Switzerland. There is very few corruption. It's always a matter of what you define. How do you define corruption? Where does it start? And I told you about this example of the law, our Renewable Energy Sources Act, which says that the operator of a wind farm must pay money to the municipality. And so the municipality will be prepared and will be willing to give their consent in the planning procedure and so on to this wind farm. And in this law, there's a special paragraph saying this is not considered corruption. It's regulated by the law that this is not corruption. But you could say it is corruption. Yes, but it's I can't give you I think more examples. Of course it exists, but I think what is really important is that you have strict laws and which are strictly and comprehensively implemented. And this is a matter of the legislation, and it's a matter of the administration, and it is a matter of the courts, of the control by the jurisdiction. This is a very general answer, but yeah, I think that's how it is.
Yes, Professor Schomerus also gave us a new concept. In Taiwan, we have a very strict concept of corruption. These politicians, if it's actually for public interest and not personal interest, they may also think that it is corruption. But if the law regulates that this public figure or politician is actually for the public interest and do these things, then it would not be considered as corruption. But for instance, we are doing this for the public goods. So in summary, I just want to say that Environmental Rights Foundation a few years ago actually did a research report for the National Human Rights Commission. Our conclusion is similar to what Professor Schomerus just said. We want to first implement the domestication of the Aarhus Convention, that is the Aarhus Convention Implementation Act in Taiwan. But for the long term, we hope that for every law and legislations, we can more concretely and see if they are in line with the requirements of the Aarhus Principle. But of course, in terms of different aspects in education, in society, and also in culturally, we all have something to improve on. And with Aarhus Principle as the spirit, we will continue to work on that direction. We run a little bit over time, but I think it's still acceptable. So finally, on behalf of all the organizers, I would like to thank everyone for sticking with us. Thank you for staying with us for the whole day, learning together what it means by environmental democracy, what is human rights within net zero. There are still a lot of things that we need to learn along the journey, but thank you very much. Also, thank you, Commissioner Ye, for staying with us. Thank you.
那以下2件事要提醒一下大家。
Just 2 things. Before you leave, please return the interpretation device. If you need to register for the training hours, please let the registration counter know. And please sign off before you go. Thank you.